Well, we're actually not sure. We're good.
We are live.
Great. This is good afternoon, the House Judiciary Committee on Thursday, the 28th of January, 2021. Members and witnesses, make sure to keep yourselves muted unless I call on you to testify or to present your bill. We will be moving through 9 bills today. We have quite a few witnesses, so we're going to try and keep things moving. All the bills are 3 and 2 bills. So in other words, the sponsor gets 3 minutes. Any witnesses will get 2 minutes. After I introduce the sponsor, I will announce who will be testifying in the same group as the sponsor. I'm usually just going right down the page of those people who have signed up. So with that, we're going to go ahead and start with Delegate Long's bill, House Bill 27. Delegate Long is here. And there are one person. It's just the delegate. Not to say that just a delegate isn't enough, but just to say that only the delegate is signed up. So Delegate Long, if you'd like to begin with 3 minutes, please.
Yes, thank you, Mr. Chair and Vice Chair. Delegate, for the record, Delegate Bob Long. I'm here to testify on HB 27. This bill actually adds to existing law that deals with certain crimes, reportable crimes in schools. We had an incident in Parkville High School where there was a 21-year-old gentleman that was convicted, charged and convicted of rape, and he shouldn't have been in the school. Anyway, this is just to add more, I would think, add more, make sure that we're all aware of what's happening throughout the state. If right now there's the only oversight is the local school board and the principal, and I believe that's part of what happened in the incident in Parkville. I believe you have 2 bills today talking about that incident also, and this would just give us more. We'll be able to make sure that these offenders that they're under the offense. There's a whole slew of reportable offenses. If they move from school to school, that does Maryland, Maryland State Board of Elections. I still got to get used to talking on this camera. Maryland Center for School Safety would be notified. Also, Maryland State Board of Education. We don't want to have the same thing happen, what happened in Parkville. We want to make sure that if someone is a danger and inside a school, we want to make sure we know what's happening. It's just to make our schools even safer. And again, this is just adding on to existing law.
Okay, that's the delegate's testimony. Are there any questions for the delegate? I don't see anybody waving at the screen. And there's one, the Vice Chair.
Thank you, Mr. Chair, and thank you, Delegate Long. I believe this is a reintroduction of a piece of legislation that was brought last year. Is that true?
Yes, and what happened because of what the circumstances with COVID-19, nothing happened with it. So that's why we're reintroducing it. It's very critical that we make sure that we have a safety net and protect our children.
Well, did this pass last session? This didn't
No,
pass
it didn't.
last session. Right.
It wasn't even heard.
Okay.
Filed
So
it late.
I think we've heard this issue a couple of times. And so is what you are asking this committee to do is that every type of reportable offense, just so that we're clear, follow that child to every single school to which they are enrolled.
Correct.
Okay. Do you think that that could possibly, do you know what the realm of reportable offenses are?
Yes, I do.
Okay. Do you think that that would have a disproportionate impact on minorities and children of color?
No, I don't. This is not about color. This is about making sure schools are safe.
Okay. I think in the past, we've seen that this would in fact have a disproportionate impact, which might be why this committee has rejected this piece of legislation in the past, but thank you.
Okay, I thought we pre-filed it late last year. I mean, with everything going on with COVID, it was definitely a mix of, anyway, it's not to disparage anyone. This is just to make sure that the rest of our schools are safe. No one wants to discriminate against anyone. That's for sure.
Okay, are there further questions
I'll just add in
for the delegate?
Google Docs document, any.
Delegate Bandari, you're unmuted. Make sure you mute yourself really quickly, please. Thank you. Any other questions for Delegate Long? All right, thank you very much, Delegate Long, for testimony, and that concludes the testimony for House Bill 27. We thank you very much. You bet. Now we have legislation from Delegates Bandari and Jackson. Also on a similar issue, but I think it's a little bit of a slightly different issue. And this is House Bill 48. There are just two witnesses here to testify, and it'll be Delegates Bandari and Jackson. What we'll do here is, it's just the two of them. So what we're going to do is we're going to give the two of you 5 minutes combined. So if one of you goes long and the other one doesn't go as long, that would be great. You can fight amongst yourselves about the 5 minutes. All right, that'd be something exciting for us to deal with, I guess. I don't know, but whoever would like to go first to present on House Bill 48, that would be great.
I would like to go first.
That'd be fine. Thank you.
Thank you. Good afternoon, Chair Kulpringer, Vice Chair, members of the House Judiciary Committee. I'm here today to present House Bill 48, Criminal Procedure Register Sex Offender Entry onto School Property. You have my written testimony on this legislation, so I will try not to be redundant. But for a little bit of background, this emergency legislation was submitted last year and cross-filed in the Senate. Essentially, a student was allowed to enroll at Parkville High School despite being on the sex offender registry for second-degree rape of a minor. Once back in school, he proceeded to victimize more young girls. He's currently in jail awaiting trial. On the Senate side, this bill passed through committee and eventually the full Senate voted to pass it. On the House side, we ran into some issues regarding federal guidelines in the Individual with Disabilities Education Act, which stipulates that children have the right to a publicly funded education until they are 21. So the district legislators spoke with Chairman Kulpringer and we met with Delegate Lutsky during the interim to try to find a way to prevent this from happening again while still complying with federal guidelines. And with this bill, we firmly believe we have found our solution. As it stands in Maryland, sex offender need written permission, a waiver of sorts to be able to attend classes regularly. The offender at Parkville, I received that permission. This bill would rectify that issue, creating a statewide protocol for dealing with such issues and making it so that the offender would have to receive their education via MSD's Home and Hospital program or via a regional institute for children and adolescents. This legislation would be the first of its kind in the nation. Similar legislation that exists elsewhere, like in Alabama and Texas, essentially leaves the decision up to boards of education or the area superintendent, as opposed to instituting a statewide protocol like exists in our legislation. After what happened in Parkville, we feel that action in these instances should not be left up to discussion. What happened stunned me as a legislator and terrified me as a father of a student in Baltimore County. It left many in our community feeling the same way. I don't believe there is any opposition to this legislation. And with that, I urge your favorable report on House Bill 48. Delegate Jackson is here to testify on this bill as well. Thank you.
Delegate Jackson, go ahead.
Good afternoon, Chairman Clippinger, Vice Chair Atterbury, and members of the Judiciary Committee. For the record, I'm Delegate Carl Jackson here in support of HB 48. When I first learned from the news media that a registered sex offender was allowed to attend District 8's Parkville High School and had allegedly raped a fellow student, an underage girl, I was outraged. And to make matters worse was to learn that this individual was on the sex offender registry to begin with after being arrested and charged with second-degree rape and had pleaded guilty to second-degree assault and a fourth-degree sex offense in a prior case. To be clear, this situation should not have happened, and this bill before us today will ensure that it never happens. I'm here to ask for favorable support, a favorable vote in support of HB 48, which will prohibit sex offenders from being on school grounds and allow for students on the sex offenders registry to be included in the Maryland Home and Hospital Teaching Program, thereby allowing them to have the benefit of a public education, but still keeping them from interacting physically with underage students, bringing this bill into compliance with current federal law, which mandates that every student is entitled to a public education. This bill also will leave some discretion to local school boards on how implementation of this program will occur. In closing, this bill will ensure that an assault like the one that occurred at Parkville High School will never happen again in any Maryland school. And also while satisfying legal requirements that all students are entitled to an education. I would like to thank my fellow district mates, Delegate Bandari and Delegate Boatler, for coming together on this legislation. And again, I urge a favorable support and thank you for your time.
All right, thank you very much. All right, are there questions for the two delegates? The Vice Chair.
Thank you, and I want to thank you both for bringing this to committee. It's an important issue. Delegate Jackson, you're making it a habit of coming to Judiciary. And I also want to thank you both for working with the chair and working with Delegate Lukey and working out the kinks from last year. As Delegate Bandari began to talk about it, I did remember the situation. So this is specific to sex offenders, and there is not a broader range of offenses. Is that correct?
Yes.
Okay, thank you. And thank you again both for your work on the issue.
Delegate McComas.
Okay, I'm getting better at this. Just a quick question for Delegate Bandari or Delegate Jackson. I know that the last bill that Delegate Long had, there was a concern that it might unduly affect minorities. I thought I'm just going to ask that about this bill. I think it's very needed and I congratulate you on it, and it's bipartisan, but I'm just going to ask that question because I'm kind of curious what you have to say about it.
Delegate Jackson, do you want to address that?
Sure. You know, I think, you know, if someone ends up on the sex registry, I think that, you know, it'll affect that person. I mean, if we want to judge the legal system, I mean, that's a whole nother issue. But in terms of someone being a registered sex offender, I don't think race would be an issue in this instance.
Delegate, if I can add quickly, and they will be placed to home and hospital program or regional institute for children and adolescent as an educator. That's an excellent program, so they don't have to miss the school or anything.
All right, thank you very much. Delegate Bandari, let's talk about that for just a second. Can you talk a little bit more about the home and hospital program for students, because that was something that I didn't know a lot about, and I think the committee would find interesting as we're effectively. I think the challenge with last year's bill is it became kind of a circular problem. They were required to go to school, but they were told they couldn't go to school unless they went to a alternative school, but that was still a school, so they then wouldn't be able to go back to the school, and we were round and round on that and ran into IDEA problems. Can you talk about the home and hospital teaching?
Yeah, thank you, Chairman. I work with Lutke on one of the bill on the home and hospital. Definitely, we need to improve that program. And currently, we do that program exists statewide. Any student who has some health issues or any type of the issues, they cannot attend the school. And what happens that they will receive the certain credit hour, teacher go to their home and they get that education. And it's an excellent program, but still we need some improvement on that.
Okay. Are there further questions? Delegate Arakan.
Thank you, Mr. Chairman. Thank you both for this really important bill. You know, I'm on the Baltimore County delegation, and that situation was horrifying. I'm just wondering when you said that, so you're anticipating that these sex offenders will then have a teacher going to their home? I'm just wondering, have you thought about how that might make the teacher a little uncomfortable to go to the home of a registered sex offender, probably by themselves, oftentimes women? Have you thought about addressing that somehow?
Yeah, Delegate, thank you. I think we are in the virtual world, and the local school system can say if they feel not comfortable, they can do through these Zoom and virtually as well. That will be the option left there.
Okay, thank you, Mr. Chairman.
All right, thank you very much. Further questions for this panel? All right, thank you very much for that. That concludes the testimony on House Bill 48. We'll go now to Delegate Mangioni's bill, House 521. It's similar, but we'll hear. Oh, I'm sorry. Did I miss? Wait a minute. Delegate Deborah Davis? You didn't raise your hand in the participants area, so I missed you. Did you have a question for the last bill?
Thank you, Mr. Chair. And I did have my hand up. It kept disappearing.
Sorry about that. Okay, we're going back then to the bill with if Delegates Jackson and Bandari. Go ahead.
Just really quick, Delegate Bandari mentioned the Regional Institute of Children and Adults. What's the connection?
Yeah, thank you. Basically discussing with Lutke, he's an expert on all the education bill, and he said that might be another plan B after home and hospital program. I can get back to you with more information on that, Delegate.
Is that part of the legislation?
Yes, they have that option. They can be placed there as well.
Okay. That is an institution for juveniles. So after they've served their sentence, to send them back to school at an institution is probably a problem.
Yeah, they are better equipped with dealing with such issues. So they're expert on that. So that is the reason why this institution is listed here.
All right. Are there further questions now on the last bill? All right, seeing none, thank you both very much. We'll now go again to Delegate Mangioni, and this is House Bill 521.
Thank you, Mr. Chairman and members of the committee. I won't be long and repetitive here. This is pretty much the same thing. I put this forth as soon as I heard about it last year. I grew up in Parkville, and I questioned the superintendent when this happened, which is why one of the reasons I put it in last year. And I'm very pleased to be here in support of this legislation, and Delegate Bandari, Delegate Jackson illustrated, of course, that we can be bipartisan. Democrats and Republicans work together to protect the children of Maryland, most important. Just a quick couple words here. Last year, for those of us that knew about the story or heard about it for the first time, horrified what happened, of course, at Parkville, where innocent children jeopardized parents, their confidence in our ability to protect the children was destroyed, really. We were there, Delegate Jackson, Delegate Bandari, myself, where we actually spoke with the victim, her mother, brave, they came forward. The failures of the institutions were really exposed. And most importantly, we just cannot have this horror, which was created by our failures. We need to protect and prevent such a measure in the future, such a failure really in the future. And we can't wait. We can't simply hope this won't happen again. And we can't rely on promises that appropriate actions will take place, which really is why we must ensure this never happens again. And that can be prevented by enacting legislation such as this, and Delegate Bandari, Delegate Jackson, Senator Klausmeyer, Delegate Boatler. So with that being said, I don't want to waste any more of your time. You've already heard all the details. So thank you for the opportunity to be here today.
All right, are there questions for Delegate Mangioni? All right, Delegate John Carden, please.
Thank you, Mr. Chairman. I just wanted to say to all the Baltimore County folks, Baltimore County in the House today, great job and very concise testimony. Thank you very much. Isn't that so, Delegate Mangione?
What was that?
No.
Sorry, I couldn't hear the last part.
Yeah, you were better off not hearing it. It's fine. It's fine. He was just celebrating the Baltimore County delegate.
Thank you, Delegate Card.
And of course, we welcome you and everything with that. But now we're going to go to Delegate Davis.
Direct any difficult questions towards Delegate Banderi and Delegate Jackson or Senator Klossmeyer.
Well, we're not done yet. Here comes Delegate Davis. Delegate Davis.
Thank you, Mr. Chair. And it appears as though I was clapping last time and not raising my hand. Thank you so much.
That's fine.
My question is regarding, what are other jurisdictions doing? I'm sure we don't have registered sex offenders. I'd like to think that we don't have registered sex offenders who are minors in other jurisdictions and schools. So have you done any research to find out what other jurisdictions are doing?
Well, it was my understanding that what happened in Baltimore County was that the way that I guess the law is written right now is that the individual could get written permission despite the fact that he had a sexual assault charge and was given that permission based on just the principal's okay. And none of the students were notified, neither were the parents. And basically, to me, that took it as, and that's why the law, if they're guaranteed the right to the education, then to figure out which of these bills are both trying to do. And I agree with Delegate Banderi, the virtual way is certainly a good way, that they chose the rights of this individual with a sexual assault background opposed to the young girls who really became victims. So I just went by basically the decision. From my understanding in Baltimore County, it was simply up to a decision and the way the law is currently written. So with other jurisdictions, that's something I can look into. That's how I gauge the law to currently be, if that makes sense.
If I may, Mr. Chair.
Sure.
So this is important legislation. I agree with that. It's just that sometimes there are less intrusive or there might be better ideas. I'd love to hear the results of your research and what maybe other states are doing and maybe other jurisdictions are doing. I'd appreciate it. Thank you.
Thank you.
Delegate McComas.
Just real quick, Delegate Mangione, quick question. I would assume, and I'm just, that a principal is not going to be an expert on evaluating someone that is a sex offender on the sex offender registry. They don't have that expertise. And isn't that so?
No, I would agree 100%.
Okay. And then the next question I have is, usually when you are trying to predict discrete behavior that is not within the bell curve, that is on either end of that bell curve, it's very, very difficult to predict human behavior. Isn't that so?
Absolutely. And I think we all agree the purpose of the bill really is to protect the students that are obviously in the classroom. And like you said, I mean, I agree with the previous delegate. We certainly want to look at every option before we finalize, but based on what happened, I think we should be able to come to an agreement that now is the time to make sure we come together and get this done to make sure it doesn't happen again.
And just real quick, isn't speed necessary? Because we don't know if we don't solve this problem this session, okay, we could have another incident that somebody is assaulted. Was that correct?
Yes, Delegate.
Okay, thank you, sir.
Thank you.
All right, Delegate Conaway, then Grammer.
Thank you, Mr. Chairman. Thank you, delegates, for this bill. So in reference to page 2, line 21, where it says where the registrant is a student or the registrant's child is a student or receives child care, what does that mean? Does that mean that the parent might be on the premises if they're on the sexual?
Anyway, I would say.
Can't hear you.
Was that, I heard somebody in the background, I'm sorry.
Yes, that's one of the delegates, I can see it. So I was asking, could you explain or elaborate a little bit on page 2, line 21 to 22?
All right, I'm trying to pull it up.
Right, I understand this is difficult. And it's talking about where the registrant is a student or the registrant's child is a student or receives child care.
No, I don't have it in front of me because it's not pulling up and the internet's going down, but I
Right,
believe.
I had to print it out.
I believe what the part about the parent is basically saying that they can pick up a child if they're on a sexual, on the list, but they're not allowed to go on the campus to get the child. I believe that's what it is, what it means.
I'm not sure if that says that, but so, and
But I have to go back and look, but of course it's
yeah,
not.
we might have to get an opinion on that. So
Yeah, that's
case
perfectly
of
fine.
line 23 through 26. Why wouldn't it be sufficient? Let's say if you get the permission, the written permission of let's say the Baltimore City Public School Superintendent, why wouldn't that be sufficient for a person who's a registrant to go on the campus?
Well, what happened here was that the principal, the way it was written, one individual made the decision. Now, that's a fair argument, but at the end of the day, we want laws. I mean, we're not going to allow the superintendent just to make blanket decisions that supersede really what we can make. If we think that it's more, I guess if the decisions comes from us that we want a sexual victim, a individual who has a sexual assault conviction, then we're making that decision that they're not allowed on campus as a body with the students, opposed to just that superintendent, which the principal, maybe well-meaning, was the one who made this decision, and the superintendent stayed silent on it because they tried to hide it. But this bill intends that we all agree, or most of us, at least a majority of us, hopefully, that this should be a decision that says we're not allowing you on campus if you have a sexual assault background.
Okay, well, I would just like to say I'm not necessarily in agreement with you, and I might have more faith in my school superintendent's decision-making ability than just giving a blanket overall bill. So thank you very much for presenting.
Yep, no, I appreciate it. And I would say that that's up to us to decide whether we want to leave it up to that one person, but I appreciate that's a great question, and it's good for the debate.
Delegate Grammer.
Thank you, Mr. Chair. Just one question. I just wanted to emphasize the importance of this. Do you remember how many victims there were? It came out one initially, and that young girl came out to testify. How many different cases were there from the one, I guess, the one person who was committing sexual acts?
So I believe he went on and committed. There was 2 victims here, and there was another one that came forth after the fact. After the first one made the news, to bring their story, to pretty much say, this happened to one, it happened to me, and it could have happened to even more if it wasn't thanks to some reporting by Fox Baltimore and the reporter, Mr. Pasp, who brought it to our attention. So yeah, there was another victim.
So it wasn't just an isolated thing. This guy continued to do this in school.
Yes.
Okay, I appreciate it.
Students. Yeah.
Delegate Erican.
Thank you, Mr. Chair. Okay, so we were just mulling over this a little bit in the chat. Okay, I remember that this case, the guy was like about 21, I think he was, and because the state law allows for continuing education until the age of 21. I just want to be clear, for your bill, you are anticipating and expecting that because sex offender registry only applies to people 18 and over, those are the people you're trying to capture, right? Because minors with sex offenses, they would be in sealed files. So we would never know about those people specifically in their sex offenses. Is that your understanding of the way your bill's written?
Yeah, and that's certainly something we can hash out. But you're right, and you probably, Delegate Archon, know more about the actual. I mean, this is one of your expertise, I know as well. Which pretty much everything is your expertise. But
very flattering.
You know, I do think that was the point here. You're right. The individual was, I think, 21 at the time. Right. But yeah, we're focusing specifically, yes, when there's 18 to, well, hard to believe, but yes, you're right.
Okay, awesome. Thank you very much.
Delegate Bartlett.
Hi, thank you, Mr. Chair. So my question might have been just answered by Delegate Erican's question. and that was if we knew how many registered sex offenders there are currently in the school system. Do we have an idea? Was that an outlier of the Parkdale situation, or is this something that?
That's a great question, Delegate Bartlett. I would like to know that myself. And Delegate Grammer was specifically talking about this particular incident in Parkville where it was more than one victim, but I do not have that answer, but I would absolutely love to know that, and something maybe we'll look into.
Actually, I was trying to find it because MSDE puts out a report, I believe every year, of the amount of arrests that are made in the school system. And they also put it out by offenses. And I was just trying to find it. And so didn't know if maybe you had already looked that up, but I'll find it. Thank you.
Thank you.
All right, seeing no further questions. Welcome to Judiciary Delegate Mangione.
Thank you very much.
We appreciate your bill. Thank you very much. That concludes the testimony for House Bill 521. For committee, for the record, when Vince McAvoy signed up to testify in favor of Mr. Mangione's bill, but indicated through communication with the committee that he is in JPR and he can't come over here. So we're now going to an issue that the committee loves to talk about and is deeply saddened that we can't all be in here in person in order to get another picture with a court dog, a court therapy dog. And so with this piece of legislation, Delegate Malone, House Bill 186.
Thank you, Mr. Chairman. Thank you, Madam Chair and fellow committee members. Today, I bring forth to you, unfortunately, without our court dogs present, a bill, HB 186, which would expand the court dog program to the Veterans Court, which, for those of you who may not know, the Veterans Court is a special diversion program designed to keep veterans with minor and nonviolent offenses out of jail. The goal was to identify underlying problems that the veteran may have to assist the veteran to being more productive in society in a healthy and safe way. In particular, veterans often, and they number in the hundreds of thousands, suffer from untreated post-traumatic stress disorder. They often sometimes have traumatic injury, including traumatic brain injury. And these things often occurred during their military service, or they certainly were made worse during the military service. Maryland law as a whole tries to strike a balance between holding individuals accountable, but with the Veterans Courts, the goal is to help our nation's heroes have a second chance. With this said, as you heard the testimony last year regarding the benefits of therapy dogs assisting child witnesses in court, this program would also provide the same assistance to veterans by providing a court dog, which in many ways can help have a calming effect and can help better assist the court and assist the veteran to proceeding forward. The goal of the Veterans Court is to provide appropriate mental health and rehabilitative counseling. With me today, you're going to hear some wonderful testimony from Judge Clavins from the Circuit Court of Anne Arundel County. And you're also going to hear some testimony from Brian Smith, who will speak in particular as to how things affect veterans. Another important component of this bill regarding court dogs is to expand it to district courts that offer similar programs. Therefore, I ask for the committee to put forth a favorable vote. There are two small amendments that are mostly procedural, and to make sure that it matches the Senate bill, which has been cross-filed, and that's Senate Bill 7. Once again, I thank you for your time, and I will yield to Judge Clavins and to Mr. Smith.
So we'll hear it for 2 minutes from Brian Smith, and we will welcome the new Chief Judge for the Anne Arundel County Circuit Court Bench, Judge Clavins, after that. So we'll start with 2 minutes for Brian Smith, though. Let's hear from Mr. Smith. Go ahead.
Okay, thank you. Good afternoon, Chair Clippinger, Vice Chair Atterbury, and members of the House Judiciary Committee. My name is Brian Smith. I'm a Gulf War combat veteran, and I'm here today to offer my support for House Bill 186. Appearing before a judge in a criminal case can be a traumatic experience for anyone, but the process can be even more difficult for veterans, many of whom suffer from PTSD. The Substance Abuse and Mental Health Services Administration estimates that 1 in 6 Iraq and Afghanistan veterans are alcohol or drug addicted or both, and 1 in 5 suffers from PTSD or significant mental anguish. That represents somewhere between 450,000 to 540,000 of our post 9/11 veterans. Nationwide, there are over 700,000 veterans of all service periods currently caught up in the criminal justice system. Tragically, that number is growing at an alarming rate as veterans are being arrested for charges directly related to trauma, substance abuse, or mental illness. We have seen the impact that veterans treatment courts have in helping veterans caught up in the criminal justice system, ensuring that when returning service members are arrested because of a substance abuse or mental health disorder, they receive the structured treatment and mentoring they need to get their lives back on track. So how can we improve the veteran treatment court's outcomes for our justice-involved veterans? Add a dog, a therapy dog, or a facility dog. House Bill 186 expands the application of the current court dog program to offer therapy or facility dog support to veterans appearing in participating county veterans treatment courts. While not considered service dogs, therapy dogs and facility dogs receive training but have a completely different type of job from service dogs. Their responsibilities are to provide psychological or physiological support to individuals other than their handlers. These working dogs are specifically chosen because of their calm demeanor and ability to work in high-stress environments, thereby decreasing the risk of creating legal issues. There is good reason to believe that providing a friendly canine presence during veterans treatment court proceedings would improve the outcomes for our justice-involved veterans. Our veterans were there when our country called, and we should similarly be there for them in their times of need. Give a veteran a second chance and give a dog a job. I respectfully request a favorable report for House Bill 186. Thank you.
Thank you, Mr. Smith. Now, Judge Clavens.
Thank you, Mr. Chairperson, Ms. Vice Chair, members of the committee. I'm Glenn Clavens, the Administrative Judge of the Circuit Court for Anne Arundel County, and also Chair of the Judicial Council's Court Operations Committee. I represent the Maryland Judiciary in support of this court dog program bill. The Anne Arundel County Circuit Court was one of the jurisdictions to pilot the original program, which was designed to assist and support children in the unfamiliar and sometimes frightening environment of a court. Our modest program has grown to 19 or 20 teams of volunteer handlers and animals at this time. It's been most helpful to child witnesses and to our judges and magistrates. I must say, as an aside, several of our judges even seem more calmer with the dogs around. But we always envisioned that this program had application beyond children. To expand the program to veterans treatment courts is a logical and needed next step. Maryland currently has veterans problem-solving courts in 7 of our district courts and 1 of our circuit courts. Additional veterans courts are desired and are being discussed throughout the state. Court dogs in a veterans court is a perfect fit. Individuals who come before these courts almost always suffer from co-occurring conditions that involve mental health and substance abuse problems. These conditions also often exacerbate anxiety and other emotional upsets that coming to court may cause. Having another resource such as a court dog program in veterans courts increases our efficiency and, more importantly, our effectiveness to provide real change in veterans' lives in order to move them towards better integration into our communities, maintaining families, and promoting public safety. The Maryland Judiciary is pleased to support the expansion of the court dog program through this bill. Thank you, and I'd be pleased to answer any questions you might have.
All right. Despite the fact that there are no service dogs on the Zoom, for which the committee is profoundly disappointed, are there questions for the panel? I don't believe that there are questions. For the panel. Yes, there is. Delegate McComas.
Thank you, Mr. Chair. I'm going to just gravitate on another issue because I think this is a great bill, and the fact that everybody's silence is also a sign that we all like the bill. I was wondering, you talk about mental health problems and comorbidity in alcohol and substance abuse, And I'm wondering if, since you all have studied this very carefully, if there's any application that could be used to expand it maybe to the local detention centers that basically feel like they're running substance abuse and mental health hospitals, or to the prison system. I know there are some programs where they do some teaching of the dogs, because we actually saw that a couple years ago in Jessup. But I just wondered if you have run across any research, and if you could maybe provide that to maybe to me or the committee, because I think it's a great, it's a great program for what you want to do, but I think there's other places that could benefit from it as well. Thank you.
I can tell you that, yeah, you were referring to the program in the women's section at Jessup, where they actually house and train dogs within that program that's therapeutic to the inmates, as well as giving us the benefit of more trained animals to come out. And that seems to be a marvelous program. But I think you're right. I think there is, long term, there's lots of applications for these service animals in all sorts of institutions. It seems that the courts are a pinch point for lots of anxieties, and that seems to be a very immediate use of these programs. We found that with children, and I'm sure we'd find that with veterans as well. But thank you for the question.
All right, any other questions? Thank you all very much. Again, congratulations to Judge Clavens. And we will, that concludes the testimony on House Bill 186. Thanks again. All right, we're going to go now to Delegate Williams. Do we have?
Yes, I'm here.
All right, yes, I see that. I'm just making sure, yeah, we still have enough to keep going. So Delegate Williams and House Bill 234, there are Delegate Williams and 3 other people, Lisa Radoff, Jennifer Bevan-Dangle, and Rosemary Kitzinger, all 3 who are going to testify in favor. So we'll hear from the delegate and then from each of those 3 people. And Delegate Williams will get 3 minutes. They will each get 2 minutes. And with that, Delegate Williams.
Good afternoon, Chair Clippinger, Vice Chair Atterbury, and members of this wonderful, probably best committee in the House of Delegates.
I'm sorry, did you say this is probably the best committee in Annapolis? I just wanted
I'm sorry, the best committee, not probably, the best committee. I'm sorry. Testifying testifying in favor of House Bill 234, also known as the Harm to Service Animals Bill. For many in our community, service animals allow for them to lead independent lives, minimizing the impacts associated with a physical, intellectual, or other disability. 90% of those who are blind in the United States are unemployed and rely on some form of government assistance. And while only 3% of blind individuals who use a service dog, 90% of those individuals who use a service dog are employed and able to lead successful, independent lives. And while many may view these animals as just being a companion or a pet, those with a service animal enjoy immense benefits from their capabilities. However, service animals are not cheap. The average cost to purchase a seeing eye dog is between $60,000 to $100,000. A friend of mine who uses a service animal to assist her because of her hearing disability paid $10,000 for her first service dog. Yet the value that they bring to the owner is invaluable, such as assisting with picking things up, opening doors, guiding people who are blind, alerting people who are deaf, or pulling a wheelchair. It is past time that members of our community are able to enjoy the use of a service dog without the constant fear or worry that their animal might be injured or interfered with. While we currently have such laws on our books, such as malicious destruction of property, which is a misdemeanor and carries a penalty for property valued over $1,000 up to 3 years imprisonment and a fine of $2,500, this bill that's before you today will not only establish stronger repercussions for anyone found guilty of causing intentional harm to a service animal, but this bill will also allow the court to enter an order for the defendant to pay restitution to the owner of the harmed animal that will cover the cost of veterinarian expenses, or worse, the replacement of the service animal. It is important that we as a legislature recognize that there is a large amount of training and costs invested in service animals and that they are beyond worthy of being protected under the law. You have the testimony letters in front of you. In addition, we also have letters from the Seeing Eye Dog Company, as well as the Maryland Veterinary Medical Association in support of this bill that you will see in addition to the letters that you saw from the National Federation of the Blind, the Humane Society, as well as Maryland Votes for Animals. If this bill passes, it will put Maryland in line with 48 other states in the country to enact legislation to protect service animals. And I believe that this bill will go a long way towards reaffirming the legislature's support for disabled Marylanders. And so therefore, I am urging a favorable vote on House Bill 234, and I'm happy to take any questions.
All right, let's hear from Lisa Radoff for 2 minutes, please.
Chair Clippinger, Vice Chair Atterbury, members of the amazing Judiciary Committee, thank you for the opportunity to testify before you today. My name is Lisa Radoff. I'm the President and Chairman of Maryland Votes for Animals, here in support of HB 234. The Americans with Disabilities Act defines service animals as dogs and miniature horses that are individually trained to do work or perform tasks for people with disabilities. These animals undergo vigorous training in order to perform their duties. While their owners often develop strong bonds with these animals, they are there to help. They perform vital tasks and life-saving duties, including, as you heard, aiding the deaf, guiding the blind, alerting and protecting a person having a seizure, and reminding a person to take medication, and more. Our treasurer's adult daughter at Maryland Votes for Animals is able to live on her own in Baltimore City because of her large, beloved Black Labrador. He helps guide her around the city, including her Braille lessons. If this dog were injured or killed, she would most likely be unable to continue these lessons and would not be able to live independently and be home with her parents. In short, penalties for harming these service animals, often on whom their owners' very survival depends, must be increased to reflect the seriousness of the integral role that they serve for their owners and to our society. I would like to thank Delegate Williams for her sponsorship of HB 234 and request a favorable report. Thank you.
Jennifer Bevan Dangle.
Good afternoon, Mr. Chairman, members of the committee. My name is Jennifer Bevan Dangle. I'm the Maryland State Director for the Humane Society of the United States. You have my written testimony in front of you. It reiterates many of the points that my colleague Lisa just made, so I will not repeat them for you. The only additional point I would love to highlight with my testimony is it's very important to keep in mind these dogs, by the nature of their service, must enter a variety of public settings that we would not typically expect of many of our companion animals. This puts them at a higher risk of, unfortunately, negative encounters with members of the public. You've heard from the sponsor and from Lisa the value of these dogs, the training they receive, and the critical role they play in enabling their handlers to live their lives. It cannot be understated how important their work is. It is incredibly important that the dog can have confidence, retain its focus, and do its job to the best of its ability. We've all heard the horror stories of dogs that have been, or other service animals, that have been injured or harmed and are no longer able to focus on their owner in scary situations because they now have a fear or an anxiety that renders them unable to do their job. It is unfortunately true that there are individuals in this around us who might cause harm to animals, who might find it amusing. And it is so important that this legislation helps raise the importance of these animals, create better protections for them, and send that strong message that these dogs are not just property. These dogs are not just a tool. They're a living creature with an incredibly important function that needs to be able to do its work. So we do urge a favorable report, and we thank the sponsor for putting in this legislation.
Rosemary Kitzinger, please. 2 minutes.
I'm Rosemary Kitzinger. I'm a resident of Carroll County, Maryland, and bear with me with the unprofessional photography you're about to see, but I wanted to show you. I'm here with my daughter, Marissa, and her service dog, Nugget, is the Black Lab. And this cute little golden lab is a 10-month-old puppy that we are now puppy raising to pay it forward since someone did that for my daughter. I will just be honest, I've testified for special education for many years now, and this is new to judicial for me, but I happened upon this bill and I wholeheartedly hope that everyone who is going to be voting on this understands that these dogs change lives. These are not pets. These are life-saving dogs that, for my own daughter with her autism and anxiety, I can tell you she's now 24 as of yesterday, and we started the process when she was 17. It took us about 4.5 years to make it through the process until she was until the organization went through, felt that she would be able to handle a service dog independently, and until she matched with a service dog, because we are told the dog picks you, and Nugget did pick her. So what I saw from the beginning is the difference in my daughter in the ability to go into public independently. I can't describe it fully, but it is life-changing. I can now attest, now that we're puppy raising this sweet girl, to the amount of training that goes into these dogs. It's not just money, it's the time, it's the effort, the love. I mean, I can't express how important this bill is to protect these sweet animals who change the lives for each individual with a disability who has one. So thank you for whoever proposed this bill. We appreciate it. And if you could just see, they're both resting down next to me while I'm testifying. So thank you. We are in support of this bill.
All right, thank you very much. There are questions. I sadly have a question that perhaps would require people to cover the ears of the animals that are nearby, but I will try to be gentle with this question for Delegate Williams. But what about service animals who perhaps are older and who have to cross the Rainbow Bridge and perhaps need the assistance of a veterinarian to make that crossing in the nicest possible way, because I think there were kids in the background of.
Yes. Understood.
What about that?
Yes. So this bill, it says intentionally or recklessly harm the animal. Therefore, if one is going to have the animal euthanized, that would not be, the intent is not to harm the animal. The intent is really to relieve the animal of any pain or suffering that the animal may be occurring because of an illness or an injury or something along those lines. And so I think because the mens rea is different than what is provided for in the bill, that would not necessarily apply.
Okay, there are other questions, and we'll start with Delegate Arakan.
Thank you, Mr. Chairman. Thank you so much for this really thoughtful bill. I just wanted to check, I was at Dulles once and there was a woman in front of me with a turkey and she was getting through security with an emotional support turkey. I just want to be clear that that is not covered in this bill, right? That this is for specially trained. Is there some kind of licensing process? Is there an organization that licenses this stuff or not really?
Yes, so this bill does not apply to emotional support animals. It specifically says service animals as defined currently under the Human Services article of the Maryland Annotated Code, which really specializes animals that are specifically trained to do certain things. And so it wouldn't apply to the turkey, or I don't know if folks saw the story a couple years ago about the peacock on the airplane as an emotional service animal, or the squirrel, but only to specifically to service animals as defined in the code currently.
Okay, awesome. I will say the lady did make it on the plane with her support turkey. It was quite interesting.
I'm sure it was. Wow.
For the record, committee, and I don't open the Human Services article because we don't usually deal with that article very much in the committee. A service animal means a guide dog, signal dog, or other animal individually trained to do work or perform tasks for the benefit of an individual with a disability, including guiding individuals with impaired vision, alerting individuals with impaired hearing to an intruder or sounds, providing minimal protection or rescue work, pulling a wheelchair, fetching dropped items, or detecting the onset of a seizure. So this is not the emotional support turkey. This is something different. Delegate Deborah Davis has a question.
Thank you, Mr. Chair. And thank you for this legislation, Delegate Williams. I share some of the chair's concerns regarding how broad it is. Did you intend that the owner of the dog or support animal be subject to the penalties? That's the first thing. And I believe you can train a turkey to detect a seizure. And so I have problems just generally as to how broad it is. And I want to make sure that the average person knows knows the distinction between a service animal and just a pet. Thank you.
Thank you, Delegate Davis, for your question. And I definitely understand the concern, which is why we didn't just say harm in general and focus solely on making sure it said intentional harm or recklessness. With, in theory, I guess I see your, with your hypothetical, if an owner of a service animal were to intentionally harm the service animal, then yes, that owner would be subject to prosecution under the statute. It's hard for me to imagine an owner would harm their own service animal, but I guess it's not outside the realm of possibilities.
Are there further questions for Delegate Williams or her panel? All right. Well, thank you all very much. We've all learned something today. That was what I read from 7701 of the Human Services article. If you want to learn more about what's in the law about service animals. But thank you all very much. And I believe that concludes the testimony for House Bill 234. Now we're going to the Vice Chair and House Bill 242. House Bill 242 has several people to testify. And House Bill 242 will be the Vice Chair, and then Michelle Smith, Scott Poyer, Casey Swegman, Pam Casemeyer testifying in favor. Then there will be people testifying opposed. So we will start with Delegate Atterbury, and then it'll be Casey Swegman. Actually, I got it out of order. Casey Swegman, Clerk Poyer, Pam Casemeyer, and Michelle Smith. So 3 minutes for the Vice Chair, 2 minutes for everyone else. And we'll begin with the Vice Chair.
Thank you, Mr. Chair, and good afternoon to the members of the best committee in the entire General Assembly, the House Judiciary Committee. So this is a new bill, but it is not a new topic. And most of you here know that I began this journey 6 years ago with an effort to end child marriage here in the state of Maryland. And I consider this a children's rights bill. During the course of the past 6 years, the House has hit different milestones and had different iterations of this piece of legislation. And I really have to say that this has been a labor of love for me from the moment that I read an article in the middle of the night one night 6 years ago, and I reached out to the Tahari Justice Center. So I need to say thank you to them because they have been with me every step of the way. I also want to thank Frady Rice from Unchained at Last, who you're going to hear, she is going to oppose this bill because she wants Bright Line 18. And I'm here to say, so do I. And so do a lot of other people that are here in support of this bill. But we know that each year the Senate opposes this legislation. And so this is an incredible compromise that I do think that we can get through the Senate this year. I also want to quickly thank, there are members of Girls Up high school group that usually come and support, but at last, it's been so much time, they're all in college now. So they have moved on. This year's piece of, well, I'm going to tell you why we still need this bill, and then you'll hear from others. Nearly 3,500 minors were married in Maryland from 2000 to 2018, most of them girls marrying men that were significantly older than them. Since 2016, every year this legislation has failed to pass, and the data shows that vulnerable minors continue to be Maryland here in the state of Maryland with no oversight, and they are being brought here from other neighboring states. So the statistics are showing us that since 2016, our state of Maryland has become a destination for men to come and marry underage girls, even when in both of the states, sex between those individuals is a crime punishable by jail time. Excuse me, Delegate Fisher. Since 2015, at least 86 out-of-state minors have come and been married here in the state of Maryland. And again, that shows us that this is a destination. I want to talk about the neighboring states. At this point, only West Virginia has a less protective marriage laws than we do. Delaware, Pennsylvania, and New Jersey, since I began this effort, have all been able to pass Bright Line 18 with no pregnancy exceptions. New York, Ohio, and Kentucky and Virginia you have to be 18 or emancipated to marry. In all, since this effort began in Maryland, 25 states have been able to tackle this issue, and we still have not been able to. You've heard in the past, you've heard me talk about the lifelong harms. You've heard that there are higher dropout rates from girls that get married, college dropout rates, a likelihood of poverty, increased likelihood of divorce, domestic violence, sexual assault, medical and mental health issues. And so I could go on, and there are others that are more well-versed than me. This bill, one more, less than a minute, Mr. Chair, essentially says, thank you. I'm almost done.
All right.
The bill essentially says that you have to get married, you have to be 17, you have to be emancipated. There will be judicial review and to approve the emancipation process, and you cannot marry someone that is more than 4 years more of your senior. So with that, Mr. Chair, I will pass it off to those who have come in support of the legislation, and I ask this committee to again give this a favorable report. Thank you, Mr. Chair, and thank you to the committee.
All right, for 2 minutes, Casey Swegman, please.
Thank you, Chair Clippinger and honorable members of the committee. My name is Casey Swegman, and I'm with the Tahirih Justice Center. I speak in support of House Bill 242. Tahirih is a legal services and advocacy organization that serves survivors of domestic violence, human trafficking, forced and child marriage. We have worked on hundreds of forced marriage cases nationwide, including many right here in Maryland. I myself am also a daughter of Maryland, and so this bill is personal to me, not just because of my work, but because this is my home. You've just heard the statistics, the harmful consequences, and how Maryland has fallen so far behind on this issue. In the past, though, you've also heard from survivors. Skylar, who year after year shared her story of child abuse, of being forced by her mother to marry a man twice her age when she was just 16, right here in the state of Maryland, and the struggle she faced trying to get help when she was still a child. Sasha, who testified last year about her own experience of forced marriage when she was just a sophomore in high school to a man who was 7 years her senior. Sasha submitted written testimony in support of this bill this year, but she's unable to speak because she is recovering from surgery. In her testimony, she writes that her childhood was taken away from her at 15 when she was groomed to be a daughter-in-law, and think of the kids she was supposed to have. This bill, which makes a limited exception to age 18 only for court-emancipated 17-year-olds, is a strong step in the right direction, and it also represents 6 years of thoughtful, lengthy dialogue and powerful bipartisan compromise. Crossing the threshold into legal adulthood makes a critical difference to one's ability to protect themselves, and HB 242 incorporates best practices from model statutes and state laws relating to emancipation, the minimum marriage age. Among this bill's key features are appointment of counsel, background checks, residency requirement, 15-day waiting period between emancipation and marriage license, and crucially, eliminating harmful parental consent exceptions, which often conceal parental coercion, and the pregnancy exception, which often ignores evidence of rape. Tahirih knows that setting the minimum age of 18 without exceptions is the strongest way to protect children from the harms of child marriage, but I am not here to make perfect the enemy of the good. This bill will go a long way to protecting children from being trapped in marriages where they are on an uneven legal playing field, abused and exploited without limited ability to get help on their own, and I thank Delegate Atterbury for bringing this measure forward.
Thank you. Anne Arundel County Clerk Scott Poyer, please.
Thank you, Chairman Clippinger, Vice Chair Atterbury, and members of the committee for this opportunity to testify in support of HB 242. For the record, my name is Scott Poyer, and I am the clerk of the Circuit Court for Anne Arundel County. My testimony today is not on behalf of the Maryland Judiciary. I am here representing myself as the elected official who's responsible for issuing marriage licenses and performing marriage ceremonies here in Anne Arundel County. I am in favor of HB 242 because I do not feel the current laws provide enough protection for minors who may find themselves being pressured into marriage. I believe there is a relative lack of safeguards for minors under the current system. While it takes two to get married, only one applicant needs to make the application, and we may never see the other applicant. We only see both if our office performs the marriage ceremony. If an outside officiant performs the ceremony, we won't see them. We just receive a green piece of paper telling us that the marriage has already taken place. And these days, anyone can be ordained to perform a marriage ceremony. You can go online, and it takes about 5 to 10 minutes and about $30 to be ordained, and you are legal to perform a marriage anywhere in Maryland. So under our current system, one spouse can fill out the application, get pretty much anyone to perform the ceremony, and they have a valid Maryland marriage license recognized in all 50 states. And no one will have ever seen the minor who was involved to determine if the minor was under duress or was marrying against their will. I support the proposed legislation because it provides better safeguards for minors by raising the minimum marriage age to 17, requiring an attorney to be appointed to represent the minor, and also requiring a court hearing for each case. Thank you very much for the opportunity to comment on this bill, and I'm available for any questions you may have.
Okay, that's great. We'll go now to Pam Casemeyer, please. 2 minutes.
Mr. Chairman, members of the committee, I'm Pam Casemeyer. I'm here today on behalf of the Maryland chapter of the American Academy of Pediatrics. I'm here to voice the clinician healthcare professionals that serve the families of children and minors and their families, and here strongly in support of this legislation. I think the Academy of Pediatrics itself would ideally like to see the age at 18, but really thank the chairman, the members of this committee, and all the interested parties who have been working on this legislation. There is unrefuted evidence of the negative implications and statistics related to minors who marry, particularly those who end up married as a result of forced marriage, higher statistics of poverty, higher statistics of child abuse, of domestic violence, higher statistics of failed marriages, higher statistics of childhood issues for the children that they bear. Terrible outcomes and terrible statistics, to the extent that the Academy without question says that it is critically important that the states put in a reasonable structure. If it's not going to be banning it outright, that there's accountability, that there's an insurance, that we have a structure that will help prevent forced marriage and all of the negative implications that occur, even when it's not forced, just the implications of youth marrying. And for those reasons, we urge a favorable report.
All right, Michelle Smith.
Thank you, Mr. Chair, and Vice Chairwoman, also the sponsor of this wonderful bill. I am Michelle Smith. I know some of you, but not all, so I'm just going to reintroduce myself. I'm here on behalf of the Maryland State Bar Association, the Family and Juvenile Law Section Council. I was also a prosecutor for 20 years, so I have a wide variety of experience as a family law practitioner as well as a prosecutor. With regard to this particular bill, I can answer specific questions. Suffice to say, our section council does agree with all of the previous testimony and Delegate Atterbury's sincere and undying interest in protecting minors in this way. We do feel that the current law does not sufficiently protect minors from potential abuse Marriage can be used to disguise human trafficking. I've prosecuted those cases myself, as well as to conceal abuse, violence, neglect, and rape by either their spouses or their parents. So we need a change. I did testify last year with regard to this bill in both the House and the Senate. I did field a lot of questions, which I was interested to see that Vice Chairwoman Atterbury has addressed in her revisions. And so the current bill as proposed, I believe, does address many of those concerns in an appropriate fashion. I could go through them, but I think that within 2 minutes, I probably can't. So we would urge a favorable report for this piece of legislation. As has been said previously, it is a compromise, and I think it's a compromise that could have success, and it brings about a necessary vetting process. The judges are going to be the gatekeepers. There's an evidentiary finding that must be made with regard to 17-year-olds, and there's a lot of steps in the process that are there to protect minors, as well as balance the interests of parents and potential spouses in situations where there may be pregnancy or a young child. So we urge a favorable report from this committee, and I thank you for listening.
All right, thank you very much. We have questions from the committee. There are 2 so far. Delegate McComas.
Thank you, Mr. Chair. This is just a question, and I'm going to kind of direct it to Mr. Poyer because he said that his office handles the marriage licenses. Do you think it would be wise to go ahead and require that both parties have to appear to get the marriage license, so that court or whoever's would be sort of sensitized to kind of what to look for, that would kind of create a red flag that there might be a problem. You also could have information regarding human trafficking and, maybe spousal abuse and things like that. And just kind of, as part of the packet that you give the parties after the license is signed, but require both parties to appear and provide identification if we can't get this bill through.
Oh, thank you, Delegate. I appreciate the question. I would say, just personal opinion, it couldn't hurt. However, if you don't want 15-year-olds getting married, don't allow them to get married. I like this bill because I think it provides really much better protection. Even if we require both parties to come in to apply for the license, I'm only going to see them for a minute, maybe 2 minutes tops. I think it is a much better protection what's written into this bill because they'll get an attorney assigned to their case. A judge will hear the case. There will be much more opportunity to hear from the underage applicant than I would ever get if they just came in and I just saw them for a couple of minutes. But yeah, it's not a bad idea. I think if you have to talk to Delegate Atterbury if she wanted to add that, but I think the protections that she's built into this bill would go a lot further towards helping to protect minors.
Mr. Chair, I have a quick question for Delegate Atterbury, if I might.
Go ahead.
Okay, thank you, sir. Delegate Atterbury, quick question. We have all heard that the human brain is not fully formed frontal lobe ability to discern and judgment until age 24. My question to you is, okay, we're gonna make it available that you can get married at age 18. Is that correct under your bill?
Well, it's 17 if you're emancipated.
If you're emancipated,
yes.
Otherwise age 18.
Yes.
Okay, so technically, you're not really ready for prime time for another 7 years, according to the scientific research. Is that fair to say?
Till about 24, 25. You want to push it off that long?
Well, no, I'm just kind of like, kind of saying, because I mean, getting married is a big deal, or should be, and yet, well, just something to think about. I mean, because we're cutting it off at 18. The question is, and then we're allowing kids maybe to potentially vote at 16. And yet, we're pushing a lot of different things, but yet they may not really be that discerning at those ages. So I just kind of throw that out as a comment and what your thoughts are.
I appreciate that.
Yes.
Delegate McComas, we ban tobacco products till folks are 21. You can't get your own divorce until you're of legal age. So if you do get married, you can't even get out of it. You can't get into a shelter. So I think you're absolutely right. And we've heard a significant amount of testimony in this committee when it comes to juvenile justice reform, where advocates have come in and said exactly what you said, that our brains aren't really developed until they are 24 or 25. So thank you.
All right, Delegate Conaway, followed by Delegate Moon.
Thank you, Mr. Chairman. Thank you, Vice Chair and members of the panel. My first question is in reference to page 3, I think line 11. The person would have to be emancipated for 15 days before they could get married. Is that correct?
Yes.
So if you're emancipated, that means that you're adult. Now, you did mention the tobacco and our restrictions, but so what you're saying is you'll be an adult for 15 days before you're allowed to make the adult decision to get married. Is that correct?
Well, you're not deemed an adult, you're deemed emancipated for certain purposes, but it doesn't change the age restrictions related to criminal laws, to having to finish school, to tobacco, and the like. So your age still remains the same for those things. You're just deemed emancipated and able to take care of yourself and or your spouse, so you can go ahead and get married.
Which goes back to page 2, line 27 and 28. Is that correct? And you have the word "and" authorized to marry. So you'll be emancipated and authorized to marry.
Correct. Yes, Delegate.
Thank you very much.
Thank you, Delegate.
Delegate Moon.
Thank you, Mr. Chair. I have a question. It's a technical question that someone flagged, and it's on page 5, lines 18 to 20 of the bill, where it says that the petitioner needs to show they're mature and capable of self-sufficiency and basically independently supported. I think that last phrase there, the intended spouse, don't we mean that they're independent of the parents? But I think we're trying to combine the incomes of the spouses, right? So that you don't want the person trying to get married to petition that they're independent without the spouse's income.
So I think what this is saying, so emancipation, aside from purposes of getting married, is you need to show that you are capable of taking care of yourself. So yes, so you are capable of taking care of yourself aside from the person that you intend to marry.
I see. So the intent of the law is that one of the ways you demonstrate you're mature enough to get married is that without a spouse, you are capable of handling your own affairs.
I would say that you are emancipated and capable of taking care of yourself. That's the emancipation criteria. The criteria for marriage is that you are emancipated.
Got it. And sorry, I didn't even mean to ask this question, but I was intrigued by something you just said about the divorce issue. So are we unable to match the divorce and marriage ages up?
So if you are emancipated, you would be able to file for your own divorce. So that would be corrected under this bill if it passes. But several years ago, this has been going on for so long, I actually spoke to family law magistrates and some judges and other folks who in the family law courts in Anne Arundel County. I mean, and that was an issue of theirs. How would somebody get divorced if they were a minor?
I see. Okay. And I hate to be totally wonky about this, but
it's your birthday. Go ahead.
Oh, I'm just intrigued. And so we're changing the law sort of midstream. And so I just want to be clear about this. The people who are married then would need to emancipate themselves in order to get divorced later, that it's not just a right that's granted by the fact that they got married.
Can you ask that again?
Like, it's possible that you just got married right now. The law is about to become.
And you're a minor.
Yeah, exactly. Okay. And so I guess I just want to be very clear that what we're contemplating is that one who also wants to get divorced must be emancipated first.
Yes.
Okay. All right. Thank you.
Where else would you rather be on your birthday than the House Judiciary Committee? Nowhere else, really. Delegate Nicole Williams.
Thank you, Mr. Chairman. My only question I have for, I don't know, the sponsor or anyone else that can answer this. I was reading the letter from the judiciary and I noticed that they made a comment, I guess, about concerns regarding the time frame or with regards to this procedure, or I guess kind of lack of a specific time frame in the bill. I didn't know if the sponsor or anyone else had a comment with regards to that concern that was raised by the judiciary.
I don't have a comment. I have to take a look at it. This is the first year they've ever submitted anything in relation to this bill. I did see it. I don't remember. I'm not quite sure what that's referring to.
Yeah, I think they were just saying that there aren't any timeframes specified in the bill. And so they were worried that, especially in the section as it relates to saying one of the parents challenging the petitioner's request for emancipation, that it can basically result in kind of protracted litigation to the point where it just sort of might even make the whole petition moot. And so that was their concern, I think, that they raised in their letter.
I'll touch base with them. I'm not clear.
Atterbury, can I just touch on how that's working in other states that have linked emancipation to the minimum age of marriage, just to assuage any concerns people might have? In Virginia, Kentucky, Texas, and other places, we have made a similar formulation to the legislation, and we have not had any situations like that arise. We have not had complaints from the judiciary around the time frame, and we have had about a 90% reduction in child marriage, so not a full elimination. But what that shows to me is that the process is working and that it's timely. We haven't had protracted litigation, and we haven't had complaints from either party or the judiciary.
If I could make one more quick comment, the way that plays out in real life in court is that the judiciary themselves institutes case time standards for particular cases. And so we could ask them to institute very strict case time standards for these particular cases.
I think that would be helpful in this situation. Thank you.
All right, we're going to go committee very briefly. I must step away here in a minute or two. I'll be back at 3:15. The vice chair is going to take over for me for a moment here, but I'll recognize Delegate Deborah Davis, which appears to be the last question before we go to the opponents of the bill. Delegate Deborah Davis.
Thank you. Thank you, Mr. Chair. I have a question about the 4-year age difference and how you arrived at that. And my second question is, can you elaborate a little more about how pregnancy affects the legislation?
Casey, Ms. Swagman, can you discuss that?
Sure. So I'll touch on the teen pregnancy question because it thankfully did not come up in JPR yesterday, but since you're asking, I'll share. In my limited testimony, I wasn't able to share this particular statistic, but unfortunately what the research bears out is that pregnancy and marriage actually doubles down on the consequences of teen pregnancy in the United States. And so assumptions that we make around marriage being in the best interests of a teen mother really don't bear out in almost every measure: education, poverty, health, you name it. Pregnant teens who marry are almost more than twice as likely to live in future poverty than their pregnant teen counterparts that do not marry. So we really see that this is actually, a piece of recognizing that teenagers who are pregnant need lots of resources. They need lots of support, but a marriage license certainly is not one of the things that is actually going to help them. And with the 4-year age difference, that really, it syncs up with Maryland's rules on age of consent and statutory rape. And we see the, extreme age differences as particularly problematic, given the more experience the adult spouse has, in contrast to the limited experience and legal rights that the minor has currently when they're entering into these relationships. the more power and the more imbalance there is in that particular relationship, and the more we see it as ripe for abuse and exploitation. And so while none of the pieces of this bill taken alone are particularly foolproof, all of them together, the age difference, the appointment of counsel, the waiting period, and the elimination of the pregnancy and the parental consent exception work to be incredibly protective.
If I'm allowed one follow-up, Madam Chair, Vice Chair.
Yes.
So does pregnancy bar the person from becoming emancipated?
No, meaning
No.
If someone's pregnant, can they not be emancipated or no?
Not get married under the statute?
Right, no, it's not a bar. It's not, but it's also not a presumption that they should be married. Okay, thank you. So I don't see any other hands up right now. So thank you to all those that came just in favor of the bill. I really appreciate it. Next, we do have a handful of folks that are here to testify in opposition. So I will wait for them to come in from the waiting room. And so first we have Vince McAvoy. I know he couldn't wait for them to come in from the waiting room. If you're coming in, please mute yourself. Okay, I'll call Vince McAvoy one more time. I know he couldn't make it on another issue. Okay, so next, Frady Rice. Was she in the waiting room, Dylan? She left. Okay, she is no longer in the waiting room, but I believe she did submit written testimony. Aaliyah Abbas, I see you here, so please, yep, feel free to go ahead and unmute yourself, and you will have 2 minutes. Go ahead.
Sure. Sure. Hi. This is my first time testifying in person. Not really in
The waiting room, but I believe she did submit written testimony.
I'm here.
Aaliyah Abbas, I see. Yes, no, for some reason there's an echo. Hold on 1 second. And you will have 2 minutes. You happen to have streaming going on?
This is my first time testifying in person. Not really in.
Ms. Abbas, do you have the streaming going on in the background? Okay, you just can't be streaming it either. So go ahead.
Sure. Yes. So good afternoon, Chair Luke Klippinger, Vice Chair Mrs. Vanessa Atterbury, and distinguished committee members. My name is Aaliyah Abbas, and I am a child marriage survivor and the activist to end child marriages. As a child marriage survivor, I request you to vote no on Bill HB 242 because it simply will not end child marriages. Voting yes would mean putting 17-year-olds in vulnerable, hopeless, and abusive situations. It is a fact that parental consent is most often parental coercion. 17-year-olds are considered children under the Maryland law who do not have legal rights to protect themselves from forced marriages. The U.S. Department, the U.S. State Department has called child marriage below 18 a human rights abuse, and a human rights abuse is never in the best interest of a child. And I would just like to mention here that, again, the human brain is not developed until 25. If it were up to me, I would, if it were up to me and I had the power to raise the child marriage age, I would raise it to 25. But unfortunately, we cannot do that. I believe that we can do better. Maryland can do better to eliminate child marriage by raising the marriage age to 18, no exception, and actually holding those accountable for this abuse. A robust judicial review process would be dangerous. It would put the child being forced to marry in a terrifying position of choosing between being truthful with the court and facing consequences at home, or lying to the court. 17-year-olds are at the highest risk of being forced into a marriage because they are close to graduating from high school, which is often the worry of parents who clearly do not want their child, girls in most cases, to become too independent. I can attest to that. Being that 17-year-old child bride 18 years ago, child marriage destroys the health, education, and the economic opportunities and increases their risk of experiencing further trauma and violence. So out of the 3,469 child marriages.
Ms. Abbas, can you wrap up?
Yes. So out of the 3,469 child marriages, 63% of those were aged 17. So I really personally do not want to leave children behind and leave those 17-year-olds in those positions where they're facing abuse of all kinds.
Thank you very much. Are there any questions for Ms. Abbas? I see Delegate Erican.
Thank you, Madam Chair. Thank you so much, Ms. Abbas, for sharing your story, a little bit of it. Could you, if you feel comfortable, elaborate a little more on what happened? What was the reasoning that your family had given for doing what they did? You don't have to share if you don't want to. I'm just very interested in the types of scenarios that this actually happens under.
Sure. So I was taken in 2003, January, to Pakistan, a foreign country, because okay. So before I mention that, I grew up in a Muslim family, and girls in Islam, it's a fact, are not given as much freedom, and getting them married before they have the independence that the United States gives at the age of 18 is, that's not favorable to a lot of Muslim families. So they would like to get their daughters married before they reach before they reach 18, where they are able to have that freedom. And so I was taken. I was married off within 2 to 3 weeks without my consent to a stranger. And I was left there among strangers who I didn't know at all. I came back and I graduated. I worked really hard to graduate high school. And then I was sent back again because my ex-husband, if I could call him that, was from there. Got pregnant, had an abortion. I was beaten, I was bullied because I was a child and he was about 25 years old and I was 17. I was beaten, I was bullied. I was put through a lot of trauma, a lot of abuse, mental, physical, emotional. And then, I was raped. I was basically told the night of my marriage, just sit and, just don't utter a word. I got pregnant with my second child again without my consent. I was sent back here. And through this whole process, I personally did not lose hope. And I still went to school. I still worked. I did all I could. And then once my son was born, I was sent back. I was raped again, the abuse, and even sitting here, when I was here in the United States, I was abused, I was tortured, by the phone calls and the constant complaining to my parents about me. And, so I went through abuse over here too at the hands of my guardians. So it's just been, I do not recommend child marriage at all. Like I said, if it were up to me, if I had the power, I would raise the marriage age to 25, but we can't do that. So I feel like we should, and I know, it's such a shame for Maryland not to pass the 18 no exceptions bill and to actually hold those accountable.
Thank you. Thank you, Ms. Abbas. Thank you for sharing your story with us, because I know that's very personal to you. And so I really do appreciate it. So thank you. Do I see any other? I don't see any other questions. So that concludes the testimony for House Bill 242. Thank you very much. Now I will call House Bill 277, which is my bill. And I will wait for those folks to be let in from the waiting room here. And that should be myself, Scott Schellenberger, Catherine Marsh, Melissa Hopmeyer, Joyce Lombardi, and Vince McAvoy opposed. Okay, so I will go ahead and get started. So this bill is 3 minutes for the sponsor, which I will not take the entire 3 minutes. And then everyone else will have 2 minutes. So thank you again to the best committee in the General Assembly. This is a very, very, very simple bill. All it does is it says, if you have continuously engaged in abuse with a child, a continuing course of conduct of abuse, then you are guilty of first-degree child abuse, because we do not have that here in Maryland. So if you're a parent, family member, household member, or other person who has permanent temporary care or custody or responsibility for supervision of a minor, which is the current law, we've added to the first-degree child abuse, if you engage in a continuing course of conduct, which includes 3 or more acts of child abuse, then you are guilty of first-degree child abuse. I want to thank State's Attorney Braveboy, who brought this to my attention, and State's Attorney Catherine Marsh, who has worked incredibly hard on this. So at this point, I will turn it over to Ms. Marsh, who I see is on here.
Thank you, Madam Vice Chair, for sponsoring this bill. Good afternoon, members of the committee. My name is Catherine Marsh, Special Counsel and Assistant Chief of the Special Victims Unit for Prince George's County, Maryland. And I want to tell you about one of the young warriors my unit has worked with, and he is one of many. He was dropped off at a hospital when he was 2 years old with numerous injuries, healing and fresh. Through the course of the investigation, we learned that from the age of 9 months old until 2, he was essentially tortured. He had healing burns from a taser, a chemical burn consistent with having bleach poured on him, whip marks that were old and fresh. We also learned from the adult witnesses in the house that our young warrior had basically been waterboarded, plunged under icy cold bathwater on multiple occasions when he had annoyed his caretaker. Because of this, he could only have sponge baths for years and couldn't even step into a bathroom when he was first placed with his grandmother. At the age of 5, he's been diagnosed with severe post-traumatic stress disorder and cognitive delay due to the year-plus of torture. Although the medical team could explain the injuries, could demonstrate that they had happened over and over again, they could not tell us to a reasonable degree of medical certainty that any one single injury had caused a severe physical injury, such as a brain bleed or brain damage, loss of function of a bodily organ, or even permanent disfigurement, as is required by Maryland law. This left us with only the charge of second-degree child abuse, which is not a crime of violence in Maryland, regardless of the repeated violence our warrior suffered at the hands of his abuser. Our victims, our children, deserve better, especially when there is a continuing course of abuse. Continuing course of abuse is not a novel idea in Maryland. We've already recognized continuing course of sexual abuse as an enhanced felony and a crime of violence. Our physical abuse victims deserve no less, and I urge a favorable report of House Bill 277.
Thank you. Ms. Hopmeyer?
Thank you, Madam Vice Chair, members of the committee. For the record, I am Melissa Hopmeyer, and I'm the Chief of the Special Victims and Family Violence Unit for Prince George's County, Maryland. And I am here to urge this committee to issue a favorable report on House Bill 277, First Degree Child Abuse Continuing Course of Conduct. As a prosecutor and as a mother, I believe that one of our most important duties as public servants is to protect our children. Children are part of a vulnerable population because they, in many instances, cannot defend themselves or even speak for themselves. I am here to urge a change in the first degree child abuse statute to add continuing course of conduct because the current state of the law does not protect our children. It allows caretakers, be it parents, grandparents, friends, or child care providers, to essentially torture a child and receive minimal penalty and accountability. You have heard the example of the warrior that Ms. Marsh just gave you, and I know that there are countless examples that were given to you in written testimony, but I want to add Abigail's story to those examples. Abigail was a 6-year-old autistic child that was brutally beaten to death by her father. But prior to her death, both her mother and her father engaged a pattern of abuse against Abigail that included drugging her, beating her with an electrical cord, and forcing her to sleep and live in her own urine and feces, as well as countless other abuses. The amount of healing injuries on Abigail's body at her autopsy were too numerous for the medical examiner to count. But because her mother did not directly cause her death, and no single healing injury reached the threshold of the current statute, which involves brain injury, starvation, substantial risk of death, disfigurement, or impairment of an organ, I was only able to charge second-degree child abuse, which, as we've heard, is not a crime of violence. Frankly, I can think of no more violent act than the beating of a child. Abigail deserved better from our criminal justice system, and so do the countless children out there that are suffering torture at the hands of a caregiver. I urge a favorable report on House Bill 277.
Thank you. Ms. Lombardi?
Thank you, Madam Vice Chair, members of the BEST committee in Annapolis, certainly the most trauma-exposed committee in Annapolis. I'm Joyce Lombardi. I am from the Center for Hope. It's a comprehensive violence center that is now part of LifeBridge Health. One of our agencies is the Baltimore Child Abuse Center. For those of you that know what that is, we don't prosecute the cases, unlike the esteemed prosecutors here, but we're the first stop before an investigation even happens. We get largely sexual, but also sometimes physical abuse cases in Baltimore and the region. And I'm here, you have my written testimony, but I'm just here to highlight a couple things that are in the written testimony. Your own Department of Legislative Services on page 220 pointed out that child abuse cases in the state of Maryland are at a really bad crossroads. We're going to look at a deluge. Right now, the number of reports of abuse is down 56% in the state of Maryland. It's not because it's not happening, it's because there's no eyes on the kids. Meanwhile, physical abuse is getting more severe. They have citations to that in there. We know from Johns Hopkins, we're seeing the same thing. You can guess, people are home, they are stressed, the children are trapped. When and if we ever get eyes back on kids, there will be a deluge of cases. And this bill, thanks to Delegate Atterbury, will be very helpful for the reasons that the others testified about. It is parity with 3315, which is the sex offense bill that has continuing course of conduct, and we urge a favorable report. Thank you.
Thank you. And Vince McAvoy and Scott Schellenberger are not in there. So do any members have any questions? Delegate Erican?
Thanks, Madam Chair. This question is for Ms. Lombardi. I did hear you mention that we're 56% down this year in reports. I had actually read an article recently that said that they thought that the reason was because 80%, up to 80% of reports, most of them coming from schools, the ones that came from schools were unsubstantiated, and that what we're really not getting are a lot of unsubstantiated reports now. Do you have any comment or data on that?
I've heard that too, Delegate Erickson, and I don't necessarily have data on that as how many are unsubstantiated. Certainly I can say anecdotally, the reports that we've gotten at the Child Abuse Center, be they from teachers, be they from guidance counselors, medical professionals, it's a mix of what's substantiated or not. I think it's one thing that I have heard is that sometimes if a report is coming from a medical person or a law enforcement, and they're also mandated reporters, chances are the injuries are going to be more severe as opposed to someone's touching me. And I will tell you this, unsubstantiated, as I think you all know from Child Protective Services, doesn't mean it didn't happen. It just means they might not have the evidence because the child is too young to give a full disclosure, or bodies don't bruise. Sexual assault doesn't, or sexual abuse doesn't usually leave a physical mark. And I think, as this committee knows, it's kind of an uphill battle. Even with excellent prosecutors, it's hard to prove these cases.
Yeah. All right. Thank you very much.
Any other questions from the committee? Seeing none, thank you very much to those that came to testify. And that concludes the testimony on House Bill 277. Moving on to Delegate Henson's bill, House Bill 93. There are 8 folks, including Delegate Henson, signed up to testify. So we'll just give it a minute for them to come in from the waiting room. There we go. Just want to give it a minute, Delegate Henson, because sometimes people come in and it's like crazy and we want to be able to hear you. Okay, looks like we're, thank you, Delegate. So this is Delegate Henson will have 3 minutes and everyone else will have 2 minutes. Thank you. Go ahead, Delegate Henson.
Thank you, Madam Vice Chair. Thank you, members of the Judiciary Committee. For the record, I am Shanika Henson, Delegate for District 30A, here to present to you House Bill 93, Public Safety, Local Youth Violence Review Committees. This bill is enabling legislation that gives our cities and counties the opportunity to bring together stakeholders to study youth homicide to prevent the next tragedy. To accomplish that, a local youth homicide review committee would do 3 things: improve coordination of services and investigations, implement changes within their own organizations, and make recommendations for state and local policy. My cross-file Senator Augustine and I arrived at this legislation as a result of thoughtful consideration and input from many interested parties, some of which you will hear from today. It is my intention that if it's the will of the committee, that 12 amendments that have been the result of that conversation would be considered by the committee in addition to the bill as drafted. The stakeholders that we've spoken with about this legislation include the Maryland State's Attorneys Association, Prince George's County Public Schools, Anne Arundel County Public Schools, Maryland Department of Human Services, Don't Die Young, Moms of Murdered Sons, Anne Arundel County Partnership for Children, Family, and Youth, Johns Hopkins Community Trauma Response, the University of Maryland School of Social Work, University of Baltimore Law School, Department of Juvenile Services, Christopher White, author, Dr. Lenny Howard of the Anne Arundel County Community Action Agency, the NAACP Youth and College Division for Anne Arundel County, We Care and Friends, the Boys and Girls Club of Annapolis and Anne Arundel County, Joyce Lombardi, the Director of Government Relations for the Baltimore Child Abuse Center, LifeBridge Health, Attorney Alonzo Robertson, Maryland Crime Victims Resource Center, Emily Burge, the Assistant Director of Government Affairs at Maryland Department of Health, the Neighborhood Youth Panel, Mr. Woody Kissel, who is with the Dartmouth Medicine College, Thomas Williams, Director of the Maryland Department State of Police, and also constituents from our various jurisdictions. We hope that the thoughtful consideration that we've given to this bill would translate into the committee also having the opportunity to review it and find value in the work that's been done by all the stakeholders. Thank you for your consideration.
Thank you, Delegate Henson. Next, Mr. Chris White. You're unmuted. Can you unmute yourself, please?
Here you go. Happy New Day. Good evening, everybody. So I'm Carter Chris White. I want the delegate, is that Vice Clippinger? I say your name right? Clippinger, Miss Clippinger?
Our Chair Clippinger, yeah.
All right. And Vice Chairman Adalbert. All right. Good evening, and everybody else that's on Zoom with us. How y'all doing today? So my name is Christopher White. I want this bill to be passed because, for one, I'm a victim of fatherless. My son was killed in 2018 on the streets of Baltimore City. And I just started going out, helping the youth, finding them housing, shelter, taking them to medical appointments. And those kids have become my kids. So the bill that Delegate Henson got, this bill can really help me because I'm in the community. I'm active. I'm going in the community with kids who got guns on them, and they coming to me with their guns on them and telling me that they want jobs. They don't want to be out there hustling and selling drugs and squeegeeing and stuff like that. So with that being said, I think that this bill needs to pass. This is the way we're going to be able to save our children. I just had a 30-year federal sentence myself. So when I see these kids on the streets, I see myself. I know what they want. They need us to listen to them. I listen to them. I bring them off the streets. I feed them. I clothe them. I take them to school. I do everything. The mayor office in Baltimore City gave me $34,000 grant. I went on the streets and I hired 10 squeegee kids and got them out the corners. Those 10 squeegee kids still living today because we had the rec centers. We had that village that's missing. What's been working in the 70s and 80s and 90s, not working in the 20th century. So we got these kids that we got now, they want somebody hands-on with them. They want somebody to listen to what they're saying. And then we tell them what, they're going to tell us what they need, and then we're going to tell them what we can do for them, and they're going to come off the streets. We need buildings. We need rec centers. We need everything for these kids. I'm just so determined that I hit the streets every day for these kids. We got to get our youth. We got to listen to them. I need the bill to pass, please. If you don't do nothing else, just pass this bill and give us a test run, and I guarantee you that we will save a lot of lives. Our murder rate in Baltimore was 355 last year. I don't want to see it get like that. So
can you wrap up?
Anne Arundel County, I seen y'all was at like 135. Let me see to be exact.
Mr. Chris White, can you wrap up your testimony because your time's up?
Okay. Everybody have a blessed day.
Thank you. Next, Mr. Robertson, and you will have 2 minutes.
Okay, you can hear me?
Yes.
Okay, good afternoon. I'm Alonzo Robertson, and I'm an attorney with the Maryland Crime Victims Resource Center.
Something just happened. You're unmuted, but the volume or something.
Sorry. Can you hear me now? Better?
It's better, a little low, but it's better.
Okay, better. Trying to use the headphones.
Okay. No?
No? Okay, hold on 1 second. Apologize.
I'm gonna go ahead and mute yourself. I'm gonna let you work that out and move.
Okay, can you? All right.
Good. That's good. That's good.
That's better. Okay, yeah, I just went right to the computer. All right, I'm Alonzo Robertson, Maryland Crime Victims Resource Center. I'm also the chair of the Baltimore City Victim Services Committee and the statewide Survivors of Homicide Network, which is an organization or a set of organizations that work to bring organizations together so that they can help with ensuring that victims of crime receive services. I want to thank Delegate Henson for this legislative proposal and for the committee for considering it as a way that we can help local youth violence committees establish them so that we can assist our children. Over the last 7 years, it's been apparent to me as a person in the community and working with youth and victims of crime that adult perpetrators of crime were as youth also exposed to crime, and either as a victim of themselves or through their family and friends. The failure of the community to consider the impact of that crime on them has undermined their confidence in the legal system and the government services that are involved. Even when organizations are doing their very best to seek out and assist victims, the failure to communicate with the organizations and themselves, or the failure to communicate between them, has a detrimental impact on our youth. The failure to consider what your policies, your procedures, and what your regulations are going to do makes it very difficult for the youth to be able to receive the services that they need. For a quick example, in domestic violence cases, youth's housing, their access to education, their emotional well-being, and even their access to health resources can be impacted. But if government organizations are only working on their particular aspect, they're missing the child that is impacted by these crises. Delegate Henson's legislation serves as a first step to address this problem, and by promoting cooperation amongst agencies and focusing on providing services to our youth, you as a delegates will be helping to determine the causes of youth violence and recommending effective changes that will ensure our future is in good hands. So I support this legislation, and I thank you for considering it and the youth in your legislative deliberations.
Thank you very much. Ms. Wright, and you'll have 2 minutes. You got to unmute yourself, Ms. Wright. Wait, it was unmuted for a second. Try it again. There you go.
Thank you. Good evening. My name is Tamika Wright, and I am here today to support the MGA Youth Violence Bill for the youth teens. I live in a community where there is nothing but violence nonstop, and it really hurts my heart to see youth and older kids being assaulted and killed because of the youth teens that were not properly raised, and on how their actions play out towards other youth teens and other people in general. I and my children just a couple of months ago experienced a very bad situation that I would not want anyone to have to participate in. It involved with 3 young teenagers bullied and jumped one of my sons over his own bike, which led to have 3 to 5 minutes neighbor, a whole neighborhood with at least 50 people or more, teenagers of all ages of children, and with grown adults that had came and assaulted my 3 children and myself, which had caused nothing but terrible violence. One of my kids had a broken hand, one got tased, and I ended up getting a black eye behind all of this. So, I pretty much strongly just want to help this bill to get passed, because I am too an active advocate in my community. I help with anything when it comes to children. I have 11 children that I birthed on my own, along with my whole community. I am also a mom to a lot of the children that I did not birth that's in my community, because a lot of them don't have parents that was raised up like me to actually help these young children that are crying out for help. I see it every day, blood on the street. And I think what Delegate Henson is doing is a very great thing to help towards, with these teens and with the kids. And I just really think that this bill will help if we can get this bill to pass. Also, it's bad enough that we're already going through the pandemic that we're in, and then with all of the violence going, it's just making our kids crazy today. So not to say and piggyback on what Mr. White was saying about all of the violence in Baltimore, but it's all over the world. So back in 2018 and 2019, there were 131 murder victims of ages 18 to 21. In 2018 and 2019, there were 89 homicide offenders against ages 18 to 21. Juvenile offenders made up 18,822 of the 178 and 890 arrested made statewide in 2019.
Ms. Wright, your time's up. Can you wrap up?
Yes, ma'am. Thank you. So I would just like to say that this could be anybody. This could be your family, my family. I just pray that we all can put something together to make this bill go through, and also to make the solution to come to a stop. Fighting strong for our youth and teens. Thank you very much, and have a blessed day.
Thank you. Thank you for your testimony, and bless you for having 11 kids. Woo. Claps up for that. Next, Mr. Harris.
Yes. I'd like to sorry, go ahead.
No, I was just going to say, go ahead. You have 2 minutes.
Okay. All right. I'd like to begin by thanking Delegate Henson for allowing me to speak on behalf of this bill. My name is Brandon Harris. I'm a college student in Davidson, North Carolina at Davidson College. I grew up in Annapolis, Maryland. That's still my home. So I was born and raised there and only down in North Carolina for school. I started a program back in Annapolis in 2016, working with teens who were involved in violence in the city, teens who are also struggling in school, in their communities, and in other ways. And we've seen great success in the kids we work with. And I just wanted to jump on the opportunity to come here and speak on the proposed bill today, because there are some benefits that I'd like to highlight. So first, this bill would enable counties or jurisdictions to look into the cases of youth under the age of 24 who are involved in homicides, and that would allow them to do a holistic evaluation. I think this is the least that the state of Maryland can do. I actually talked with Delegate Henson about the possibility of making this a requirement. There's no reason why people under the age of 24 should be involved in homicides without a holistic review being done. Obviously, the criminal investigation or evaluations will take place, but there's other areas that need to look into where they failed that individual over his lifetime, his or her lifetime. Could the schools have done better? Could the local health department have done better? Could local nonprofits do better? These are three, and there are many more groups or areas that could look into how they could have specifically done better to help the individual to avoid the situation that they were involved in. There should not only be a criminal investigation into what happened in that child's life.
Mr. Harris, if your time's up, can you wrap up, please? I'm sure I see some members have questions, so you might have.
I just like to say that I'm confident that the possible good that this bill will bring out significantly outweighs the possible negatives that anyone thinks it could bring. So I would hope that you all would consider what I said and support the bill that Delegate Henson is proposing to y'all today. Thank you.
Thank you. And I see the chair is back. Mr. Chair, we have one more to testify and there are some questions. Mr. Powell, you have 2 minutes, Mr. Powell.
All right, good afternoon, everyone. My name is Craig Powell, and I would like to thank you for this opportunity to offer my support for this bill and the vision of Delegate Henson. I support this legislation because I believe that the framework for this service model has a unique and important opportunity to uncover deeper insight into the factors that contribute to youth violence. With a focus on youth wellness by local violence review committees, I think that this model would result in greater consideration into the various sources of trauma that young people are exposed to and the impact of trauma on their emotional well-being that all too often, whether we see it or not, it frames their perspective about the world around them. It frames their perspective about their lives and their futures. I would also like to mention how critically important I think the collaborative aspect of this legislation will be in serving youth. I think convening a diverse committee of local stakeholders who bring their varied experiences, perspectives, and cultural insights to these committees is an encouraging prospect. So I believe that the model for these committees could result in access to data and insight that could be shared with organizations and really systems charged with serving youth to better inform their work, not only here in Maryland, but ultimately nationwide. And in closing, I would just say that I think it's innovative approaches like this to serving youth that will result in us seeing more positive outcomes with our young people. I think our young people deserve laws, programs, services, and strategies that consider what all too often they don't consider, which is that they were born with righteous purpose on their lives. So I'm optimistic that the work of the Youth Violence Review Committees will eventually serve as inspiration in reminding us all that our young people were created on purpose for a purpose. So I certainly hope that you all will give serious consideration to this bill. I think that it is certainly transformative. Thank you.
I think the next person to speak, I believe, is Tamika Wright. No, she did? Okay.
We're just on to questions.
Oh, okay, we're on questions. So Delegate McComas.
Thank you, Mr. Chair. This is for, let's see, the lady that had been assaulted with her kids and one of the children broke their hand. Were those children prosecuted that harmed your family?
Right now, they have been charged and it's still pending. We have a court date coming up.
Okay. Have you been, let's say, intimidated by the parents of the children or the children at all because they have to go through this legal process?
I have, by the children and by the adults, yes. And that's one main reason why I'm trying to help get this bill to pass, because it needs to stop. It's getting worse every day. And, not just only for my children, but for all the children in the community and all over the world. And I just think that if something be placed and done and this bill get passed, I really believe that we can help our youth. And I'm just one that is willing to try to help these youth. I'm going to even ask them to try to get some like a mediation or some type of help, because I don't really want to see the kids go downhill. I wouldn't want to see that for nobody's child. I am a mom. I just want to see the kids get some type of help. And if they don't get any help, then it's just going to be worse for them and for any other kid that come along.
Mr. Chair, could I have just one follow-up? That's not really a follow-up, but it's a question. Do you feel, what do you feel is the major problem? Do you feel that the police are a major problem for the system at this point? Because we're getting a lot of legislation that about the police in Baltimore City and all kinds of issues versus other things. I mean, if you had to say, if I had to say, what is the biggest problem that you feel? I know you're supporting this bill, but what do you feel is the biggest problem in the city, and the problem with what the youth have to deal with?
I would say the biggest thing is it's a combination of different things. One, it starts at the home, with the parents raising their children. Two, sometimes the police need to be more involved, I would say. And the reason why I say that is because we have police in our neighborhood, but they can actually sit and see some of the things that's going on and nothing is really being done. It could be a different combination of different things. I think if we had more programs and everything that we're doing to try to fight this bill, if everybody can just get along, the school systems, the police department, the juvenile systems, everything that Delegate Henson said, and everybody that's supporting this bill, I really believe if we all can just come together and make this happen, that something good and great will come out of this whole thing. But I can't really pinpoint on just one thing. It's just a combination of different things.
Thank you very much. Thank you, Mr. Speaker, or Mr. Chair.
All right, so for those keeping score at home, I've been called a judge, the speaker. Okay, that's fine. Chairman's fine. Let's stick with chair. All right, we're going to go to Delegate Bartlett. I understand that Pam Brown has entered the room, but we'll go to Delegate Bartlett's question, then we'll give Pam Brown the opportunity to speak. All right, so Delegate Bartlett.
Thank you, Your Honor. So I wanted to point this to Brandon Harris. Brandon, I met you when you were this high. Oh my gosh, I can't believe it. It was in an ice cream shop in Annapolis. And I met you, and just that one little conversation, I think you were in line behind me or in front of me, that one conversation that we had, I knew it. I knew you were going to do big things. And here you are testifying on behalf of this bill. I am so proud of you. I cannot tell you how proud I am. That brief moment changed my life. I just want to let you know that. And I wanted to say to Ms. Wright and to Mr. Powell, thank you for the work that you're doing and for your community. Brandon, my question to you is, will you come back if this bill passed and after you graduate from college, if you come back to this area, will you either mentor or work within the local committee if this bill were to pass? Because we need you back here on this side, because the work that you are doing and the work that you are going to do is absolutely tremendous. Mr. Powell, I like the way you said it, that we all have a righteous purpose and the youth have a righteous purpose. So Brandon, will you come back and help us out?
Yeah, let me just respond to your first statement about meeting you in the ice cream shop. That's, the reason why I was able to make it here today is because I've been supported. I've had the resources and opportunity to thrive and take part in these types of experiences. And I think that as delegates or as lawmakers, I think that it's your responsibility to try to make sure that other kids can be on calls like this to have their voices heard as well, because there's many good thoughts and ideas that we have as a generation, and I think that they should be acknowledged. To answer your question about coming back to the state, if this does pass, yes, it's no question, I'll be back in Annapolis, willing to serve on these boards because I see how important they are. One of my plans actually is to, continue to involve myself in Annapolis, in Maryland, as much as I can while I'm gone. Real quick, let me say that I'm also here at Davidson working on an independent study to look into cases of youth violence in Maryland. So I'm actually starting to communicate, hopefully, with Dante Harris, who many of y'all know was unfortunately involved in the homicide of Amy Caprio in Baltimore County, tragic event. But I'm currently trying to get in contact and learn more about how the state, city, and counties have failed him to help him to get to that point where he's now facing life in prison at 17 years old, and the police officer is dead. So thank you.
Thank you.
All right, we're going to go to Delegate Conaway, and then I have not forgotten Pam Brown. Delegate Conaway.
Thank you, Mr. Chairman. Thank you, panel, for coming in. This is for Ms. Wright. Do you have any ideas what we could do to be proactive about these type of situations, like what you were involved with, where we can teach the children, teach a person how to respond in a non-violent way to a situation where maybe their bicycle is taken or their car is jacked or something like that?
Yes, I would say I have a lot of ideas. Several. I have a whole list. I would
One
say
or two would be real good right now.
okay. I would say that in a situation where when my son's bike got taken, maybe if some of these organizations can come along and maybe help purchase bikes for them, or either just put more activities out for the kids so they can have something to do. Some more field trips and things. I have a whole list.
All right. Thank you so very much for your testimony.
You're welcome. Thank you.
All right, what we'll do now is we'll ask Pam Brown to speak for 2 minutes. We'll see if there are any further questions, and then we will move forward. All right, Pam Brown, please.
Good afternoon, Chair Clippinger, delegates. I'm speaking in favor of this bill. I've been working in the field of youth safety for many, many years. I am the executive director of the local management board here in Anne Arundel County. I'm also a sitting member of several review committees, including child fatality review, opioid review, and so on. I think the importance of this bill lies in bringing all of the actors together to review not just what happened in this particular instance of violence, but what has happened throughout the years related to a child's life. One of the things that happens in reviews committee is that we just don't review the now. We look at when did we see this child over the years? When did he first come to our attention? Why didn't we do anything in the second grade? Why didn't those things happen? So it gives us an opportunity as human services workers, police, community, and so on, health departments, to really look at comprehensively what we could have done better throughout the life of a child, and then review the incident itself. The hardest thing from our point of view as service providers is that sharing information is so incredibly difficult. So we can't just tell one another about a child for a whole set of reasons related to confidentiality and other statutes. Review committees allow us to talk to one another, allow others to take part, and allow us to review the many, many things that have resulted in a piece of violence. And I think I'll just end by saying the neighborhoods where a lot of violence has taken place are also neighborhoods where the social determinants of health are very high, where there's an enormous amount of trauma, enormous amount of adverse childhood experience related to poverty, institutional racism, and all of those other things. And while this bill will not get to that, it will certainly help us to talk together about interventions that should have happened and did not happen many, many years ago.
All right, are there any questions for Pam Brown? Okay, seeing none, I believe that completes the testimony for House Bill, yes, House Bill 93. We thank Delegate Henson quite very, very much. And thank you. And we will now be moving on to our next bill. Thank you all very much. Now, House Bill, our last bill, House Bill 71 with Delegate Lutke and 1, 2, 3, 4, 5, 6, 7, 8, 9 witnesses on top of him. So what I'm going to do, Delegate Lutke, do you have any preference for who you'd like to go first?
No, I'm happy to defer to you and sign up order. I think, you'll hear.
You are, as usual, completely unhelpful, and I appreciate that. And we will then just go with the following. It'll be Delegate Lutke, Arti Sidhu from Disability Rights Maryland, Megan Collins, Michelle Smith, and Secretary Abed. And I think that'll be good enough for the first panel. The speakers, the delegate will speak for 3 minutes, everybody else for 2. And let us get underway. Thank you all very much. Delegate Lutke.
Thank you, Mr. Chairman, Madam Vice Chair, members of the committee. Happy birthday, Delegate Moon. So the Article 8, Section 1 of the Constitution of the State of Maryland says as follows. It says, the General Assembly at its first session after the adoption of this Constitution shall by law establish throughout the state a thorough and efficient system of free public schools. It's one of the most basic promises we make in our Constitution. It's really, aside from passing a budget, the only thing that the General Assembly is specifically charged with in the Constitution. And that applies to students everywhere, including in our juvenile services system. We provide educational programs through the juvenile services facilities for those students who are not able to attend school in their home school because of living in a facility for a period of time. And I think you'll hear from the folks that come after me that there are a lot of challenges with the education that's currently being provided. And I will say, I personally do not ascribe fault about this. I believe that the system that we have for governing our juvenile services education program is not built to do the job. And here's why I say that. Currently, juvenile services education programs are managed by the Maryland State Department of Education. The Maryland State Department of Education is an oversight and accountability agency. It does not run schools. So the idea that they would have the ability to run the schools is tenuous to begin with. On top of that, the only independent oversight offered and on a governance basis is from the State Board of Education, which obviously has a lot of other jobs to do. So what this bill proposes, and it's the result of multiple years of work with a huge range of stakeholders, is to move the governance of the juvenile services education programs under a new school board that is created within the Department of Juvenile Services. That school board would hire a superintendent. They would be for all educational, curricular, and hiring decisions completely independent from the department. The department would house the school system and would provide, through its existing procurement processes, an opportunity for the school system to not have to recreate a procurement system from scratch, not have to create a new HR system from scratch. We believe that this transfer of responsibility would, first of all, provide a focused, independent form of governance for the education programs in our juvenile services facilities. We believe it would be more efficient, that it would provide a better education, that it could potentially be done more cheaply. And we believe, most of all, that it would be of tremendous service to the children who are involved in the juvenile services system, who have a basic right to a high quality education. And by providing that education, we will help reduce recidivism. We will help make sure that the young people, when they leave the juvenile services system, are able to better re-enter society. So I'll cut myself off there, Mr. Chairman. Thank you for the time.
Thank you. We'll go next to Arti Sidhu.
Thank you. Good afternoon. My name is Arti Sidhu, and I'm a co-chair of the Maryland Coalition to Reform School Discipline, also known as CRSD. I'm a staff attorney at Disability Rights Maryland, and I'm also a mother. I'm here today on behalf of the Maryland Coalition to Reform School Discipline in support of HB 71. CRSD is a group including, but not limited to, advocates, service providers, and concerned citizens. We work to transform school discipline practices to be responsive to students' behavioral needs and ensure a fair and equitable education for all. As we know all too well, Black and Brown students and students with disabilities are disproportionately impacted by the school to prison pipeline. A fair and equitable education is one of the best ways to counteract this impact. Numerous administrative complaints filed with MSDE over the past several years have uncovered a host of problems with JSE's basic educational services, special ed, and other related services. Further, COVID-19 has only made matters worse. While JSE purports to offer live teaching, students report not having any live interaction with their teachers and being sent packets instead. Many times these packets are erroneous, they're the same that they've received last year's, or they simply don't even apply to their coursework. Students are blocked from important educational resource sites, they have trouble accessing their course curriculum, and trouble submitting assignments. This is simply unacceptable. Even in a general education public school, there are disparities in academics and in discipline for students of color and students with disabilities. Now, being part of the school to prison pipeline, they face even more challenges. We cannot create a world-class education system for Maryland without including all of our students, including those in juvenile justice programs. It's imperative that students' needs need to be addressed and they're provided with quality education services and access to resources. We hope that a creation of an independent school board will remedy some of these barriers that they face. Thank you for listening and thank you for your time today.
Thank you. Megan Collins, please.
Good afternoon, Chair Clippinger, Vice Chair Atterbury, and members of the committee. My name is Megan Collins, and I'm a staff attorney at Disability Rights Maryland. Disability Rights Maryland supports House Bill 71. As Ms. Sidhu mentioned, Disability Rights Maryland has been advocating for years for improved educational services and outcomes for students in juvenile services education. We were involved in the state complaints filed with the Maryland State Department of Education. As with other societal issues, the COVID-19 pandemic has only exacerbated the problems with the current juvenile services education model, and it's clearer than ever that the system needs significant changes. The Blueprint for Maryland's Future proposed a funding scheme that would create a world-class educational system for Maryland, and we hope that the creation of an independent school board would ensure that the students in juvenile services education are afforded the benefits of this world-class education. Education is a primary strategy for curbing recidivism and keeping students out of the school to prison pipeline. We want to stress the importance of providing improved education services for students in state custody, particularly in juvenile justice programs, in planning for the success of our state. These students cannot wait any longer for significant changes, and they are entitled to improved outcomes. We believe that something must be done to address the structural barriers to providing quality education to all of our youth. It is our hope that the creation of an independent school board would remedy the structural barriers such as lack of staffing, budget, and curriculum availability that this vulnerable population of students currently faces, and would ensure that youth and juvenile justice programs have greater access to quality instruction from certified teachers, course availability, and planning for transition back to the community. Thank you.
All right, Michelle Smith.
Thank you, Chair Clippinger, and good afternoon, committee and Vice Chair Atterbury. I am from the Maryland State Bar Association, the Family and Juvenile Law Section Council, as you probably have already heard earlier in this session. We are urging a favorable report for House Bill 71. It is the position of our practitioners that deal with juvenile matters that this is long overdue. The education programs within the Department of Juvenile Service detention facilities are currently inadequate for the children that are in those programs. There are, as you have already heard from the other people who have testified, it has been documented that the students placed in those schools have not been receiving appropriate education per our Constitution. So we believe that House Bill 71 is a necessary change because it brings about a detailed and thorough, a comprehensive structure, an independent structure to establish a juvenile service education system. Undoubtedly, this is going to benefit not only the juveniles who are within that system, but the community at large, because statistics show that education, which is a right of all of our children, but it also provides a decrease in recidivism for those children who are within the juvenile justice system. So we urge a favorable report for House Bill 71.
And now the Secretary for DJS, Sam Abed.
Thank you, Mr. Chairman and Madam Vice Chairman. It's a pleasure to be with you today. I'm Sam Abbott, Secretary for the Department of Juvenile Services, and here to testify in support of House Bill 71 as well. I'll try not to retread what has already been said, but as an operational agency with an independent monitor, DJS has developed a number of tools and systems to allow us to track data elements down to individual workers and individual youth, and manage decision-making with our staff. We report that data annually to you for transparency's sake, but more importantly, we take all of that data and use it to guide our decisions. House Bill 71 leverages all of that investment of managing with data while maintaining an independent education system. And it does this by taking the operational and ancillary functions, as Delegate Lutke mentioned, like human resources, information technology, research and evaluation, procurement, and moving that within the Department of Juvenile Services while keeping the education decision-making with a board that is connected with an independent, but connected with the State Department of Education, higher education, and local school systems. This will address some of the longstanding challenges that our education program has had with regard to ancillary services like teacher vacancies, which lead to gaps in the curriculum offerings and with ensuring that students are receiving the level of services that they should. We should have a robust and transparent outcome and accountability measures for juvenile services education. In my role as secretary, I am statutorily responsible for ensuring that our youth receive education services. However, in the current framework, I nor my team have sufficient access to education records. Basic metrics like how many hours of instruction a youth is receiving are also not available. And without this information, it is impossible to evaluate the efficacy or success of the largest program that operates in DJS's facilities. And for these reasons, I urge a favorable report on House Bill 71. Thank you.
Okay. Are there questions for the sponsor or the witnesses? We'll start with Delegate Ron Watson, please.
Thank you, Mr. Chairman, and good to see you again, Secretary Abed. Thank you, Delegate Lukey. Quick question. 2 summers ago, we had the ability to take a tour at, I believe it's called the Baltimore Central Booking Intake, and housed inside was a high school. We had the opportunity to speak with the principal of the high school, who actually still fell under the auspices, I believe, of Baltimore City public school system. So with this bill and a separate Board of Education, the Board of Education will now be responsible for oversight for all schools within DJS, or is it all educational programs within DJS?
So all educational programs that are part of juvenile services education, we did build into the bill the flexibility as currently exists for the board to devolve the running of specific programs like that one to a school system or another institution. Because there are a couple programs that are not currently, and Secretary Abed can name them, I'm sure, that are not currently on a day-to-day basis overseen by the Department of Education, but rather kind of handed off to other systems and organizations.
Right. I did see the provision where the bill allows DJS to contract with the County Board of Education. That's what you're referring to, right? And so it's interesting because when we went there, it was stated to us that these kids, once they were in this type of environment, they actually excelled. And it wasn't until after they left that facility and went back into their normal environment where there was a lack of, consistency in their lives, they reverted back to sometimes normal behavior, and the grades suffered as a result. And so I guess what I'm saying is, I absolutely support anything that helps our kids, particularly our impacted and incarcerated youth. So my last question is, currently within the DJS system, how many high schools are there?
Delegate, if I could just address the first question, because I believe that there's a little misunderstanding there. The school that is operated by Baltimore City Public Schools is actually the school that is housed for a Department of Public Safety facility. That's not a DJS facility. That would not be covered here. That is a different school, and I have visited that school as well. It's an excellent facility, and it's a well-run operation, but that is not one of our facilities. That's a Department of Public Safety facility that was built to house youth charged as adults that weren't eligible to come back to the juvenile system, or young offenders that were transferred to the adult system. So that's a different matter. In terms of the number of schools, we have a school in every facility. So each of our facilities has its own school.
And so, Secretary, as you're collecting metrics, will those metrics roll up in the state superintendent's, typical manner in which they do their thing, or you will be providing your own separate metrics to us to let us know the efficacy of this program and how you implement it?
So the way that the statute resolves that is so that the board would work with the department and our independent monitor, the Juvenile Justice Monitoring Unit, to develop those metrics. And the idea here is that we do have a quality assurance system that already goes out and visits all of our programs and evaluates them. We would be adding the evaluation of education programs. And so those metrics haven't been developed, but they would be developed with that school board. And that school board is mentioned in the statute. I believe it's 11 members, and it contains members that are appointed, and then also members that are there by their position, like myself, the state superintendent, and the superintendent of higher education, for instance. So we would have that group of experts to consult with and to develop a set of metrics that we would then be able to publish. And of course, as in all of the cases where we report data, it's a living document. Like our data resource guide is a living document. So we publish what we think we need, and then we hear from our partners and from our stakeholders. And if there are areas that we're blind on or something that we've missed, then we can of course add those in as we go along.
And so my last question, for the school settings, we are talking about high school diplomas, not GETs, correct? We're talking about
Yeah, that's what they work towards now, because the children who are involved in the DJS system are not always there for multiple years. So the majority of them, what happens is they're there for a short period of time, and their presence there, because the programs that exist are not adequate, actually interferes with their ability to get a high school diploma, because they miss the opportunity to get course credit for required courses they need to get their diploma. By creating this system, we believe we'll be able to correct that and help get these kids on a path towards that regular diploma.
All right. Thank you for the bill, Delegate Lukey. I look forward to seeing the first round of metrics that come out.
Thank you.
Delegate Deborah Davis.
Thank you, Mr. Chair, and thank you, Mr. Lukey, Delegate Lukey. At first glance, this looks like separate but equal, and I don't like it. Why not give each of the facilities a board of education and put them under the same system? Help me with that.
What do you mean?
It sounds like separate but equal. Square that for me.
Sure. So, the juvenile services programs are provided under essentially an existing system that just doesn't have an oversight board, right? And that system is separate from the regular school systems. So this would this sets up a unified juvenile services education system. The other model we looked at for dealing with the issues here was the idea of devolving the management of a facility within a particular jurisdiction to the school system in that jurisdiction. The bill as written would allow the school board here to make those kinds of decisions. But we didn't end up relying on that solely as a model, because there are some county school systems that are frankly better able to absorb management of these types of programs than others, depending on the size and the size of central office, and also the expertise of specialized programs here. I don't know if that gets at what you were asking, Delegate.
If I could add one thing, Delegate Lukey, to your response, the school standards would still have to be followed, the statewide standards. Mm-hmm. When we talk about the metrics that we want to add, they're really the metrics about the standards would be evaluated by, does your plan meet all of the school standards? The metrics are to see, are we actually delivering that on the ground? So if it says you're going to get 6 hours of education a day, did you get the 6 hours of education? If you have an IEP, review that IEP and evaluate, did they get all of the services that they were supposed to get? Those are where the metrics are. The standards don't really change. It's just enhancing the accountability and the transparency of the data that we produce.
If I could follow up, Mr. Chair. Couldn't that best be achieved by keeping all the kids in one system? The oversight in one system, so everybody has the same oversight, everyone has the same expectations. When you start setting up a whole different department for children that have gone through the system, I think it's a slippery slope.
There's a separate department for all the students who are involved in juvenile services now. It's just under,
and it's not working.
Right. I'm not sure what the alternative would be, right? The challenge here is the current system's not working. It's not working for a range of reasons. Part of the issue is, the State Board of Education just, they have a lot to focus on. So this would be a group of people who would be specifically focused on provision of education within juvenile services facilities. And the requirements for who would be appointed require people with expertise that is particularly applicable to education within a setting like this. So I'm not sure what the alternative would be to that.
Could I try and speak to the question? I sat on the work group that was convened to try and discuss possible options to make recommendations to the legislature back a few years ago when this question was first raised, because as Delegate Lukey pointed out, There are sort of two ways of handling this, and it differs by state. And some states are, in some states, the schools in the juvenile justice system are managed by the county in which the school is located. And in some states, it's handled by a separate school district. And in Maryland, instead of having a school board, the board has been so far the Maryland State Department of Education. And I might be oversimplifying this, but essentially what we were considering on the work group, and one of the issues that came up that I just wanted to raise as to why it maybe doesn't make sense to have it with the local school systems, is that sometimes students, when they enter the juvenile justice system, end up in a location that isn't in the school district they're originally from. And so there's transferring back and forth between school districts, and it makes it a more seamless process if it's all managed by one juvenile services education board that is able to coordinate that back and forth, and they're able to have the management of the different courses and the management of the transfer back to the local school systems, rather than students going between districts within the state and additionally into the juvenile services education system.
Okay, I'm going to go to Delegate Robin Grammer now.
Thank you, Mr. Chair. Good to see everybody. Brief question for the sponsor, and I'm not just trying to bust your chops on this one. What was the cost on the bill? I didn't see it on the fiscal note.
There isn't an increased cost.
Okay.
It's essentially the best fiscal note I've ever had.
Fantastic. Then question for the secretary. So, Mr. Chair, if you remember several years ago, we passed a bill that allowed a senator and a delegate to be part of the new juvenile fatality team, and that team reviews every time a juvenile dies within the purview of the juvenile justice system. And I was appointed to be the member on the House of Delegates on that team. And for at least a year now, I've been reviewing the cases where youths have died within the juvenile justice system, or at least under the prerogative of the system. And one of the themes in reviewing all those cases is a lack of engagement in the education system. So I wanted to ask the secretary, if you pass this bill, how does that change the circumstances for a student who is completely disengaged with his education already?
So let me just clarify a little bit, and thanks for the question, Delegate Grammer, and thank you for your support by serving on that committee, because I think it is a very beneficial group to review those homicides. These are not deaths that occur in custody. We have not had any deaths in custody.
Correct.
Thank goodness. These are either youth that are victims of homicide in the community, or have been or perpetrators of that homicide in the community. And yes, the education piece has come up repeatedly, but it's been their disconnect from education in the community. It's not really focused. I don't think this bill would address those issues, because I think what we've seen in those reviews is that we'd have kids that have been lengthy periods of time where they're not engaged in school, but those are in the community schools, not in the facility schools.
Sure. And one more question. So we had our hearing on a separate bill earlier in the year. Ms. Shapiro testified. As you know, she was part of the reform committee at one point, and she said, she expressed that she had concerns that she didn't even want students to be, or she didn't want youth to even be engaged in the juvenile justice system at all, because analyzing the data per her testimony, at any time a youth was involved with the Department of Juvenile Services, they had a bad outcome. And her suggestion was create, a further board, further organization, so that youths didn't have to be involved with law enforcement or prosecutors or the courts or the juvenile justice system. And I said to her, it seems, what if that group doesn't facilitate what you're looking for? And I get the feeling that we're kind of just like shifting things around here. So can can you help me more understand more clearly how this wouldn't be duplicative? You know, this was going to offer something new to either the youth or Department of Juvenile Services that you're not getting now.
Delegate, it's a fair question, and let me try to address it. You know, I've spent my career as an educator. There is no child who is beyond reach, right? But we fail not just a lot of kids in the juvenile services system, but tens of thousands of kids all over the state every year because we never reach them for a whole host of reasons, right? I personally think that the instruction that happens in our juvenile services facility should be the best instruction in the state. Because a lot of times, like you say, these are kids who have been disengaged with school, who haven't been reached, who haven't had, you know, adults who have worked closely with them, right? We have failed these kids. And they end up in a juvenile services education system where when a teacher leaves, it takes 6 months to replace them. So they don't have any consistency. Where the teachers in the JSE system get paid less for 12 months of work than a teacher in a regular county school system gets paid for 10 months of work. So we're not able to make sure that we have consistently strong staff at all times in these schools. Where kids who have special needs and IEPs are not having the accommodations in those IEPs, which are legally required under federal civil rights law. Those kids are not having those accommodations delivered. Where kids who, you know, were maybe on track for graduation experience what is essentially interrupted education, aren't getting the high school credits they need to graduate, and are returned back to a home school with, you know, little choice at that point besides getting a GED or dropping out. So, you know, the bill does its job by creating a structure that we think will work, that academics and advocates and educators and DJS think will work. And I'll tell you, it hasn't been easy to get to this point. The Senate sponsor and I originally started attacking this problem from two very different perspectives, and we were working across purposes for a while, but we're all on the same page now. You will not get the quality of education that these children need and deserve under the current system. You need experts who are focused on providing the best possible education in an independent school board, and you need to solve a lot of these basic problems like hiring issues and procurement issues that have stood in the way of providing the type of education they need. So I hope that gets to what you're asking in your question.
I think so. Thank you.
Mm-hmm.
Delegate Conaway, then to McComas.
Thank you, Mr. Chairman. Thank you, members of the panel, for coming in to testify. My question was really for Ms. Sidhu, if she's still here. I was looking at her testimony, and it starts out with the Maryland Coalition to Reform School Discipline. And then she spoke about being interested in transforming school discipline practices. So I was wondering, what ideas did they have, or did the organization have, to help with the school disciplinary practices? And are there standards or booklet or something like that that the students get to review to know what type of behavior is expected of them before they get in trouble? So I don't know if anybody can, oh, there you go. How you doing? If you could answer that.
Yes,
for me,
I'm
I
here.
appreciate
Thank
it.
you so much. I apologize for my child you may hear in the background. I think he really wanted to testify today as well. So as the Maryland Coalition to Reform School Discipline, we do a variety of work across the state in discipline, largely to counteract exclusionary discipline policies and instead focus on our more restorative practice. I apologize for him.
It's okay.
So if I answer your question clearly, there was a work group put together after 2017, the Restorative Practices Bill, the Maryland Commission I believe it was the Maryland Commission on the School to Prison Pipeline and Restorative Practices. So that's one of our guides that we use in talking about school discipline and what we recommend across the state. So I'm not sure exactly what you're looking for. There's a variety of things that we recommend and that we hope to see change across the state of Maryland. But that's one report that I would say is great to review and try to answer that question.
Well, if the chair were giving permission to use the delegate's name. Delegate Davis was alluding to the situation, and what are you doing to not have two systems, but to make sure that everybody's in line on the one system? So if identified as having a behavior problem, let's say in the 9th grade, something could be done. What type of disciplinary practices do you have to develop behavior before it spins out of control where they would be required or need a second system?
Certainly, absolutely. And I think the main answer to that is restorative practices. So instead of focusing on things reactively, focusing on them proactively and shifting school to have a positive response and to encourage rehabilitation and reformative practices at the onset rather than in response when something negative happens. Now, when we talk about this bill, I think the important thing to acknowledge is that the education students are getting in the juvenile system is different than in the public school system. So that's why we're talking about two systems here. But overall, and starting in our public school system, we need to be more proactive. When something is wrong with the student, we need to ask why. We need to look at what their home life is like. We need to see what kind of supports they have, rather than just reacting to a particular fight or a particular instance that happens and saying, okay, we're sending you home for 3 days and then bringing you back to school as if nothing happened. So I think restorative practices are really part of the answer to this question. But of course, it's much more complicated than that.
Thank you very much. Have a good day.
Thank you.
Delegate McComas.
Sorry about that. My question is basically, I suspect that if we have a separate school, and this is maybe for Delegate Lukey or anybody else that wants to chime in, that this will allow basically the teachers to be more specialized in dealing with populations that have significant problems, whether it be discipline, home life, IEPs, because I think you mentioned that we're not keeping up with the IEPs now. And I guess what percentage would that be? But in other words, this really allows us to do a much better job for these kids. So they're not going to go, it won't be school to prison pipeline, that they're going to get their life in order and they're going to get inspired, hopefully, and find out, what they like to do and sally forth. So if you could comment on that.
Yeah, look, I mean, that's the goal. And, I should step back and say thank you to the members of this committee, because, we've been having discussions in Ways and Means for a while about school to prison pipeline issues. And, because it's a school to prison pipeline, both our committees are deeply involved in it. And Delegate Conaway asked exactly the right question a second ago, right? Which is, what are we doing in the schools, long before a kid ever gets to the point where they might get involved in the juvenile services system. And so we've long-term been trying to adjust disciplinary practices in schools to better address those concerns, to prevent the school to prison pipeline where it starts. But we do have kids that end up in the juvenile services system. And we need to make sure that they are taught by the best possible staff, that they're provided the highest level of curriculum, and there are specialized needs. I mean, for example, and I'm not obviously going to sit on this new school board if the committee chooses to create it, but I think every educator in these programs should be duly certified in general ed and special ed. Because the special ed training, first of all, there's a higher incidence of special education need among the student population. But second, the special ed training lends itself particularly well to managing students in a productive manner who come to the classroom with a lot of challenges. And so, I think that's what we'll end up seeing. If we make these types of changes, it'll put us on a road towards a high quality level of education in these programs.
Okay, I think that's all the questions for this first panel. We're going to go to the next panel now, but thank you all very much. We'll go now to Grace Reusing, Nick Maroney, Peter Leone, Dr. Barbara Desmond, and I know that John Willems is also signed up here. He's signed up favorable with amendments. We'll add him into this panel. But committee, just please be advised that that Mr. Willems is favorable with the amendments. The other two are all favorables. So we'll just go from there. Just do this for a little bit of efficiency. So let's see, Grace, are you there? Grace? We'll add him into this panel. Grace, we're using?
Yes.
Are you there? All right. You will get 2 minutes and everybody here will get 2 minutes and I will start that now. Please go ahead.
Thank you. My name is Grace Rusing and I'm an attorney with the Office of the Public Defender. We are in support of HB 71. In 2013, I did not know a thing about education law. I was a criminal defense attorney. But it was that year that I started working with detained juveniles, and I was contacted by teachers and a former JSC principal sounding the alarm that the MSDE takeover of the school system was not working. That was 8 years ago, and the system is still broken. Since 2013, I have filed over 40 special education complaints, documenting the egregious shortcomings that bar educational equity to our clients. From students not having their IEPs implemented, to inadequate course offerings, to the lack of individualized instruction, and to leadership that does not have the track record or any real experience in operating or implementing educational services to at-risk youth. And I could go on and on. Since I have limited time, I've attached to my written testimony a 43-page document that provides the data to prove that the current system is not working. But I think many of you already know that. I think the real issue is this bill going to solve the problem? And we think it is. I think most importantly, it's going to provide I'm sorry. I just realized I wasn't on.
No, you are on. We can hear you. It doesn't.
Okay, just not my camera. I'm sorry.
Yeah.
Is this going to solve the problem? And this is why we think it is. It's the most important thing. It's going to provide an independent school board with the autonomy to appoint a superintendent. And although JSES has made some improvements over the years, it's far too little and way too late. There has been a decrease in the number of special education complaints that I've filed in recent years, but that's because I've had to direct my limited resources to other systemic education issues affecting our clients in community schools and in the adult detention centers. Because spending my time documenting all the JSE school issues through the school complaint process really wasn't making an impactful difference. But I think that's what this bill does. In my opinion, to do nothing at this point and to decide to keep the status quo should be intolerable, because we all know that a failed education system only strengthens the school to prison pipeline. And I think that's what you'll be doing if you decide to keep the status quo. And for those reasons, we support the bill.
All right, thank you very much. We'll go now to Nick Maroney.
Good afternoon, Chair, Vice Chair, honorable members of the committee. I hope you can hear me. Yes, okay, very good.
Yes.
I'm here representing the Juvenile Justice Monitoring Unit. Some of what Grace talked about in terms of the documentation that she offered includes our reporting throughout the years. I've been reporting on services for kids and abuse-related issues in DJS detention and placement for about 13 years. And the problem in terms of education is that the system has been plagued by substantial problems, resulting in substandard education resources for incarcerated young people. And high school graduates also remain unengaged. And these problems continue to affect the kids. MSDE does not collect the kind of data that's necessary and appropriate to accurately evaluate its services. In the past, when the Department of Juvenile Services and the Juvenile Justice Monitoring Unit, which is an independent unit in the Attorney General's office, have asked for pertinent data on how the kids are doing, we have been given attendance data. In that attendance data, we were told that in the DJS detention facilities, in the youth education services blocks at the detention and placement facilities, that the attendance is very good. It's in the 90th percentile typically. This is not really the kind of information that we're seeking. We're seeking things like the secretary talked about earlier. How many hours of actual education are the kids getting? Are all of the kids who have IEPs actually getting all the services delivered? And what's happened is we've had to go after things, as has Grace Rusing on the part of the public defender, case by case. And we have found that there's still problems to this day. What the bill offers and why we're supporting HB 71 is that it sets up an oversight that is responsible basically for what happens. It's the equivalent of a county Board of Education, and they will be consisted of education experts, appointed and otherwise. And we think that those are the kind of folks who need to be in charge of education within the facilities, because those are the folks that bring the specialty to the table. Until something is done in terms of proper oversight, evaluation, and data, we're going to have the same problem continuing. I should also add that I've been authorized to represent for the record that the Attorney General supports this legislation.
Thank you very much, Mr. Maroney. All right, Peter Leone.
I'd like to thank Chair Clippinger, Vice Chair Atterbury, and members of the House Judiciary Committee and Delegate Ludke for bringing this important bill to our attention. My name is Peter Leone. I've recently retired as a professor at the University of Maryland College Park. For my entire professional career, I've studied education programs for youth in custody facilities. I'm the former director of the National Center on Education, Disability, and Juvenile Justice. In 2006, I was selected by the state of Maryland and by the Justice Department to monitor the implementation of an agreement between the Justice Department and the state of Maryland concerning education at Cheltenham, at the Hickey School, and the Baltimore City Juvenile Justice Center. In 2004, as many of you know, the General Assembly transferred the authorization to run education over to MSDE, and many thought it was a good idea at the time. Some of the issues raised by Secretary Abed, Mr. Maroney, Ms. Rusing, have to do with structural problems in inadequate monitoring that I think are addressed by this particular bill. In my estimation, MSDE has been unable to deliver in part because there's lack of accountability, there's lack of autonomy, there's lack of oversight. I do believe that there's people in the system right now that want to see kids get services and the supports to which they're entitled. But the current system, I believe, is unworkable. I have, over the course of my career, worked with folks in lots of states. I currently monitor Illinois. I've just begun as monitor of the Los Angeles County Juvenile Halls. And I got to tell you, it is possible to deliver high quality education services that ensure that kids get excited about what they're doing, that kindles a spark for some of those kids that haven't experienced that prior to their incarceration. So I urge the committee to move favorably in support of this legislation, HB 71. Thank you.
All right, thank you very much. We'll go now to Dr. Desmond, please. Dr. Barbara Desmond. Dr. Desmond?
I'm here. I had to unmute myself.
There you go. You're good.
Thank you.
2 minutes.
Thank you. Good afternoon, Chair Clippinger, Vice Chair Atterbury, and representatives. I'm Dr. Barbara Desmond. I've come today on behalf of the Maryland State NAACP and the National NAACP in support of the House Bill number 71. As many of you know, some of you may know, I have a long history of civil rights dating back over 60 years. Had the opportunity to interact with and learn from persons such as Clarence Mitchell, Thurgood Marshall, Elijah Cummings, Perrin Mitchell, Ben Cardin, Paul Sarpin in person. Pardon me today if I sound impatient, but at my age, I realize that my time to make any positive change is running out. As a result of investigations which began in 2014, both the National and the Maryland NAACP found failure of the Juvenile Services Education Program as conducted by the Maryland State Department of Education. Consequently, we filed a multiple 100-page complaint with the Federal Office of Civil Rights. Most of the children in the centers are Black and male, a historically endangered population. Reviewing how evident the situation has been for so long, one must begin to doubt if the deplorable education conditions would have been tolerated so long and easily had the majority of the children not been Black offenders or considered by some to be offensive. In Maryland, these children, as all others, have an essential right to a quality education. These are our children. It's time to stop warehousing them and hiding them. They have had no voice, and those who have spoken for them, including myself and others in the past, have been shouting in a vacuum. This is an opportunity for Maryland to demonstrate that Black lives matter and that all of these children matter. Their lives matter while they are young and can benefit from another chance. And HB 71, with its focus on reform and accountability, can help give them that chance. The Organization of Human Rights for Kids, which focuses on juvenile justice throughout the nation, recently released a report that ranks Maryland as one of the worst states in the nation for protecting children's rights in the justice system. It is time to move beyond futility, excuses, and promises to do better. House Bill 71 presents an opportunity for us to rectify wrongs that have existed too long. As Nelson Mandela himself, a detainee, powerfully said, "There is no keener revelation of a society's soul than the way in which it treats its children." I beg all of you representatives, I beg you to search your souls. Thank you.
Thank you very much, Dr. Desmond. All right, just to be clear, John Willems is here with favorable with an amendment. So we'll hear from him and we'll take questions for all 5 after this. John Willems.
Mr. Chairman and Vice Chair, members of the committee, John Willems, representing the Maryland Association of Boards of Education. First, I want to endorse virtually all the comments and testimony that I've heard today in support of this bill, reflecting the work of Delegate Lukey, and I think somewhat chronologically ahead of him, Senator Kelly. And she spurred MABE's interest in this. And I will emphasize, I think, a point that's been made, but is perfect for MABE to make, is that board governance matters. For too long, and perhaps never, has there been a board devoted to exerting its governance authority over the sound administration of these schools and the students who have every constitutional right and moral expectation to an education within these schools. And so it's high time that a board be established for purposes of governing these schools. And so we fully endorse that approach. The one amendment I would draw the committee's attention to, we do have concerns. Look, we're not wild about high stakes testing and setting up barriers to graduate for students who experience challenges to meeting the mark. But we did just pass legislation last year that waived not all graduation requirements, but graduation requirements in excess of the minimum 21 credits for homeless and foster children who move between school systems in their junior or senior year of high school. That's appropriate. That 21 credit standard is appropriate. But waiving all standards, we do have a little cause for concern about doing so on behalf of any student who comes and goes from the DJS system in 11th or 12th grade. And so some 11th graders could be in and out for a short period of time, and waiving all graduation requirements for them might be something to consider modifying. But beyond that, and the funding provisions we know we can work out, we're fully in support of this bill. Thank you.
All right, thank you very much. So questions for this panel, again, keeping, not to pick on John Willems again, but keeping in mind that Mr. Willems is favorable with amendment. Delegate Grammer.
Thank you, Mr. Chair. Question for Mr. Maroney. You talked about insufficient data that was currently collected. Can you elaborate about that, please?
So I think that one of the things, Delegate Grammer, and thanks for the question, one of the things that this bill sets up is a situation where data can be properly gathered and evaluated. We haven't really had significant data from Maryland Department of Education. When we've gotten close to it, when Dr. Leone was contracted with them to look at their system, he wasn't enabled to complete his final report. So we didn't get the data that we wanted. It's kind of the opposite of what I find as a monitor when I'm looking at DJS. There's a plethora of data. It's a matter of trying to figure out, okay, what the rubrics should be. Should we be measuring this? Should we also look at that? And they've been pretty open to expanding both the depth of the data and the broadness of the data that they put out in their data guide every year. We've got absolutely nothing remotely like that coming from the oversight of education in the juvenile justice system.
Can either you or Mr. Leone expand on what kind of data you're looking for?
Do you want to talk to that, Peter?
Sure, I can speak to that. So in some systems, in some states, the ways in which credits are measured are quite differently than what we do in Maryland. So for example, if a youth spends, let's say, 6 or 8 weeks in a facility in Maryland, there isn't adequate data to suggest that he or she may be able to earn partial credit. They return to a school system that says you're going to have to either retake the course or you're going to have to start again at the beginning of the next semester. And so you can picture a youth who thinks that time spent in classrooms while incarcerated makes a difference, only to be told that it doesn't. So we don't have data about how often that happens to kids. This has been a long-standing problem that MSDE has not been able to address, and I'm not exactly sure why, but that would be one example. So, credit accumulations, career technical education, we have no indication of how many certificates kids earn. There are short-term certificates like those offered by OSHA or by outfits like ServSafe. There's different kinds of things like that that could be measured, that could be used to provide information to the General Assembly as well as the general public about how kids in the system are doing.
Okay, thank you. And a question for Dr. Desmond. Can you go into briefly, you mentioned some deficits in the school system, especially for minority communities. Can you speak about some examples of that for the committee briefly, please?
Oh, you're speaking to the juvenile justice schools?
Yes.
Okay, all right. What we found with the NAACP is that, and I could go through a list and I will be glad to share with you the complaint filed with civil rights. We found that there were not resources for as a matter of, and these we interviewed, I don't know, the state is coming out with some type of report, MSDE, which finds them more favorable. But we found, I interviewed people and the national sent in delegates, interns to interview persons. And we found that, like in one school, for instance, just to give you an example, there was a room full of computers, over 35 computers, sitting there for over 2 years, never been connected. We had children who had gone back to school with no record of what they had accomplished. Children were being educated according to the housing unit, not according to their grade level. Therefore, you might have a class in arithmetic or mathematics ranging from grades 5 through 9 to 10. And they would all be taught the same thing out of the same basic text. Yet when they came back to their schools, they would all get different grades for different grade levels. Let's say you were being taught 5th grade math, and what they would give the child would be a grade in algebra at the 9th grade level, which would be totally false. There were cases in which MSDE offered, these children would do compensatory education. Ms. Rusing and I, for instance, just this past year, walked into a session with a school system attorney who I will say had a smirk on her face and blankly, and there we are with a desperate parent saying, what can I do to help rehabilitate my child? And the attorney looks at us and says, well, I'm sorry you didn't reach the deadline. There's nothing we can do for this child. But finally, we had a hearing officer who helped us. There are tons where many of the people who work in the centers, the school administrators, et cetera, some went on record, but as Ms. Rusing will attest, some were just terrified that their careers would be impacted if they told us of what was happening. We went through IEP after IEP, and we would say, well, what's going on? Tell us how we can help the children. What are you doing? If you look at the reports that we have, MSDE would admit, we did not do this, we did not do that, we did not do this. And we asked at the NAACP, how can you freely admit that you didn't provide the services? What MSDE would then do would be to send out an apology. Well, we're sorry we didn't do it, but we know, well, basically there's no consequence. These are the situations that have gone on that we hope would be resolved. We have met with the assistant superintendents, we've met with the former superintendent. We just think that at this point in time, the only solution is to try something new.
All right, I appreciate that. Thank you.
You're welcome.
And if you could maybe send some examples to the committee via email, I think that would be great. I'd love to read it myself.
I would like to send you the entire report if I could.
Thank you.
Thank you.
Seeing no further questions for this panel, we want to thank you all very much for spending part of your afternoon with us. Thank you all for, thank Delegate Lukey for the bill. And that concludes the testimony on House Bill 71 and the testimony for the bills today on the 28th of January, 2021. We're going to have a voting session tomorrow at 2 o'clock, and we will see you all then. Have a good day. Thank you very much.
Thank you.